May I, my lord? My lord, I beg to mention item number 6 and 7
Hearing.
on behalf of N. Kumar. I have taken consent from the other parties also. So matter may be kindly fixed on 15th June.
On behalf of,
N. Kumar.
is for the petitioner.
Yes, my lord.
Okay. Mr.
P. Harming.
Land Council appearing on behalf of Mr. M.
N. Kumar.
Where is his name?
It is reflected in the cost list, my lord. Wakalat nama.
Okay. And Kumar, Land Council for the petitioner with the consent of Land Council for the other side. Mr. Mato is present. Okay. Praise for adjournment of the matter to be listed on 15th
15th June.
June
Yes, my
with
lord.
Mr. To which Land Council for. You're also here.
I'm okay.
Okay. With Mr. Chaudhary, Land Advocate General from CNL and Mr. Mato Kato, who are also present, has no objection. The prayer is allowed. List this matter accordingly on 15th. Yeah. Okay.
Deeply honored.
Millet, I'm mentioning item number 3. The senior counsel, Mr. Tara, he's out of station, Your Lordship.
Okay.
And with the consent of the other parties, the matter may be fixed, may be listed after a week, Your Lordship.
Probably affidavit also not yet filed here in this case. Okay. You have taken consent.
Yes, Your Lordship.
Okay. Mr.
Peer on Your Lordship.
Land Council submits that the conducting council, Mr. T. Tara, is out of station. Therefore, pray for adjournment of the matter for
A week, Your Lordship.
a week. The prayer is he has also obtained consent from the of the Land Council for the other side. The prayer is allowed. List this matter after.
After a week,
Week.
Your Lordship. Next week.
Okay.
Oblige, Your Lordship.
Item number 1 and 2.
May I visual option, my lord? I am on my lord VC.
Yes, sir.
My lord, these two matters are analogous matters. And these two matters, my lord, have come for admission. Basically, my lord, this to appeal was initially barred by limitation, delay was condoned, then matter is fixed for admission. So, my lord, whether lordship will hear the entire matter or lordship will just, my lord, admit the matter. Because
What to do?
it
Admit?
may require some time.
Probably it need consideration.
For
Yes.
admission also, it is considered.
My lord. So, my lord,
Because,
this two,
I'm raising some very serious objections.
Okay.
The appellants don't appear to have come before this court with clean hands.
Okay.
They have suppressed even materials that were before the learned single judge, even in the appellate stage, they have suppressed all this.
They have received according to you already.
Otherwise, there is nothing in the case, my lord. Even on merits, there is nothing in the case.
Okay.
So even if your lordship takes it up for admission, my submission is that your lordship will hear me, and thereafter
Okay.
take a vote. If he wants to argue, I'm ready.
So
We'll hear them out if they are ready.
okay.
my lord.
But as Mr. Chaudhary, as far as suppression is concerned, that has been already considered by the single judge.
All aspects have been considered.
That-
The issue is otherwise very simple, man.
Hmm.
They were given the
My
benefit
lord,
of the
let me, my lord, submit
let him-
first, my lord.
Yes, yes, yes. He was just explaining nothing. We are not hearing him.
My lord. My lord, lordship, they are all along raising the question that there is a suppression, there is a suppression. What is the question of suppression? What is the suppression? Let them point out. We have come, my lord, for claiming our area salary, which accrued under 5th and 6th CPC. Government took different stand at different point of time. Sometimes they are saying, my lord, there is a negotiation taking place with the parent organization ATA. Sometimes they are saying it is a policy decision. Sometimes they are saying financial constraints. Did they ever raise this question in 2014 or 2003 writ petition? Continuation. It is a continuation, present writ petition. Writ appeal is a continuation of original writ petition of 21 of 2014. Did they ever raise any question, my lord? That there is a special material facts? Am I not entitled, my lord, to claim area salary? Now they are saying, my lord, everything is paid. Had everything is been paid, then what is the question to issue the impute notification? How do you say, my lord, you are entitled to get the notional benefit without any monetary benefits? pay commission, my lord, was adopted by the state government without any modification. Now, I will, my lord, explain in what manner government is to exercise the power. Section 42 of the, my lord, Arunachal Pradesh Act, 1986. That aspect was not even considered, my lord. I was not even allowed to argue on this point. You have your power to exercise, and by exercising the power, you are to adopt the policy, my lord, pay commission report, and without any modification, we have, my lord, adopted. And within period prescribed, which is 2 years. I'm just reading, my lord, the relevant portion of the, my lord, section 48. 46 of subsection 2.
What is this?
Yes, my lord. Well, my union is here, my lord. She will provide, my lord. Because original compilation, my lord, there is a missing of, my lord, that particular provision, 46. I'm just reading, my lord, for your lordship consideration. My lord, section 46, continuance of existing law and other adaptation. All laws in force immediately before appointed day in exercise of the Union territory in existing Union territory of Arunachal Pradesh shall continue to be in force in the state of Arunachal Pradesh until altered, repealed, or amended by competent legislature or other competent authorities. Therefore, they adopted everything of the central government. Therefore, you have your discretion to make amendment, to make alteration. Now, subsection 2, for the purpose of facilitating the application in relation to state of Arunachal Pradesh of any law made before appointed day, the appropriate government may within 2 years from that day by order make such adaptation and modification of the law, whether by way of repeal or amended, as may be necessary or expedient, and thereupon every such law shall have effect, subject to adaptation and modification so made until altered, repealed, or amended by a competent legislature or other competent authority. Upon paragraph 15 of their affidavit, which they filed in the original writ petition, paragraph 15 of the original writ petition, also have it, and you have a local. Now, in my compilation, my lord, or should find their affidavit. Civil opposition dated, my lord, 13/9/2023, annexure 12 at page 423. Original, my lord, appeal memo.
Page?
423. No, 423, huh? Just a minute, my lord. I'm sorry, my lord. 312, annexure 8, 312. No. I will also call my lord relevant page 315. 318. Paragraph 15 of their affidavit. Because our whole contention is that you have your discretion to make necessary amendment, alteration, etc., etc. If you do not make any alteration or modification by taking a cabinet decision, then it is binding on you. We are not saying, my lord, government doesn't have the jurisdiction. Government has the jurisdiction. We are not going to dispute. Now, paragraph 15, what was their stand regarding our contention? Our whole contention before the writ court was that there was no modification, no alteration, nothing of this sort. You did not exercise any power under section 46(2), and accordingly you adopted. Now, paragraph 15, I'm reading, my lord. The humble, have you also got, my lord? Paragraph 15.
Yes.
318. What is their stand in reply to our contention? humble deponent admits that the statement made in paragraph 16 of the writ petition. However, the humble deponent submits that the state government has got overall discretion to alter or amend or modify or substitute or refuse to accept the recommendation made by CPC from time to time as admitted by the petitioner in the corresponding paragraph 16. Emphasize supply. The respondent state never modify, alter, or amend. Never modify, alter, or amend the said recommendation of the CPC to any considerable extent. What remains, my lord? If your own stand is that there was no amendment made by you by exercising power under section 46(2), why should not we are entitled, why should you not be entitled to claim area salary?
Read the
In-
entire
Malak-
sentence. Kindly let us read the entire sentence.
Yes, yes. Alter, amend, or recommendation of the CPC to any considerable extent doesn't mean that same was waived by the right to effect the discretionary alteration or change. They said that we didn't alter, but doesn't mean that we cannot. Therefore, the question we are asking, where is the alteration? Where is the cabinet decision? Otherwise, there would not have any question to issue my lord impugned notification dated 15/2/2013. You are not entitled. You could have straightway said that government took a policy decision, therefore we are not going to pay any area salary. That was not. Now let kindly say the impugned order, which is the whole, my lord.
No, Mr.
Part
Purkayastha,
of the-
Mr. Purkayastha, before going there,
Hey, my
you
lord.
just explain the mechanism, how, if there is a recommendation from CPC, how it is implemented in a state.
The government is to take a decision by through cabinet.
But how you just tell us how it is to be done exactly. If there is a recommendation from CPC, how it is implemented? Is
Right.
it by 309 rule or by a cabinet decision? How?
My lord, I have just read my lord, section 46(2), 46, 46 and 46.
46
law
to
that-
says what? That's a different
46
thing.
Yes, 46(2), for the purpose of facilitating the application in relation to state of Arunachal Pradesh of any law. This ROP is the central government rule based on my lord recommendation of CPC.
But is it CPC? I mean, CPC's recommendation is a law.
Yes, my lord, ROP rule was my lord, ultimately framed on the basis of that recommendation.
No,
And
but
ROP rule
that's
was
what. See, CPC is recommending something. Now
Right,
state has to adopt it or negate it, whatever. Now, if
Right.
it adopts it, how it is to be done? I mean, is it by way of a 309 rule or by cabinet decision? What? So you'll have to explain the mechanism.
My lord, Roshi, kindly appreciate. Recommendation
Yes.
means certain suggestion given by commission. Now it is
Yes.
for the central government or state government to accept or not to accept. Sometimes
Correct.
central government may not constitute a high power committee, etc., etc. Therefore, central government recommendation was accepted by the state government subject to certain modification. And if you want to modify or make any modification or alteration, then you have to exercise power under section 46(2). This is the source of your power. We are not saying state government doesn't have the power. Therefore, once the power is exercised, materials, once the power is not exercised, and ultimately, my lord, ROP rule was framed by the central government, and in 89, government, by exercising power under subsection 2, my lord, adopted central government ROP rules. ROP rule is made applicable. Now I am coming to my lord, to that extent, my lord, adaptation rule. Arunachal Pradesh adaptation law and order. Yes. Now, if you kindly see, I have also given a copy of my lord, Arunachal Pradesh adaptation of laws and orders. This is in terms of, my lord, section 46(2). A copy is, my lord, possibly, my lord, given to your lordship, my lord. Have you lordship got, my lord?
Yes,
It is
yes.
also, yes. Yes. Now, lordship, kindly see. My lord, at page 12. A single page passage, my lord. Now, therefore, in exercise of power, aforesaid government of state of Arunachal Pradesh hereby makes the following order, namely, these are the rules, my lord, of the central government were adopted by the state government. Now, my lord, serial number 13. Serial number 13. Central Civil Service Rules. The Central Civil, as your lordship knows, my lord, ROP rule is based on, my lord, recommendation of the pay commission. State has got also, my lord, a separate ROP, for example, in Assam, and state government, Arunachal Pradesh, adopted the central government ROP rules. Therefore, ROP rule is a statutory rules which is framed by the government of India on the basis of recommendation of pay commission, and which was adopted by the state government. So this is the mechanism, my lord, and on the basis of that they used to provide. And that question was never, my lord, disputed by them. Therefore, whatever is provided under that rules, we are entitled. ROP rule says that 6 pay commission is implemented with effect from 1/1/2006. And my lord, it is for that reason the government has made negotiation. Government has constituted a high power committee. In our writ petition annexure 3, and annexure 4, I think it was. A high power committee was constituted by the state government for the purpose of examining the feasibility of various recommendations made by Central Pay Commission. And accordingly,
Annexure 4 is at page.
my lord, I'm giving, my lord. My lord, at page 221. This is the high power committee. Kindly see, my lord. At page starts from 221. Next page 222. This committee is my lord, committee constituted by the state government for the purpose of examination of various, my lord, feasibility or acceptability of various recommendations made by CPC. They have worked out. What they have worked out? They worked out what will be the financial implication of the state government. If they are to, my lord, accept the recommendation of state government, the claim made by ATA. Before that, my lord, it may be element on my part to point out that before constitution of high power committee, there are three members committee was constituted by the government. 3 members committee also suggested that the claim made by the association is genuine. And accordingly, it was, my lord, kindly say annexure 4. Annexure 4, there is a suggestion made by the high power committee to government to, my lord, make a negotiation with the association so that there may be a, my lord, compromise, or there may be a, my lord, ultimately there may be some settlement. Settlement regarding what? Settlement regarding area salary. My lord, I am reading, my lord, paragraph 7 at page 223 of the high power committee report. Have you lordship got, my lord?
Page
Page
223.
3. ATA has earlier renounced the claim against the arrears up to 31/12/2005. There are 2 slabs, my lord. Our whole claim before the deed court, we, my lord, sought for a SCB relief to release our area salary for the period with effect from 1/4/98 to 13/3/2013. It covers by both the CPC, my lord, 5th and 6th. Ultimately, in terms of the, my lord, suggestion made by high power committee, government made a negotiation with the ATA. ATA is the parent association of all the teachers. Now, ultimately, they arrived at a conclusion. Although, my lord, we made a specific contention. Doctrine of waiver doesn't have any application so far as my substantive right is concerned. I cannot waive my right. Even then, my lord, even assuming that there was some negotiation, what was the, my lord, settlement? To what extent ATA had relinquished their claim? First part of the claim was relinquished by the ATA. It clearly appears that, my lord, the ATA has earlier renounced the claim against ADR up to 31/12/2005. Therefore, their specific claim was with effect from 1/1/2006. 1/1/2006 is the relevant date on which, my lord, 6 CPC was, my lord, given effect. Therefore, our claim for the time being, my lord, if first part goes, well, because of renouncement, though renouncement is not permissible in law, doctrine of waiver doesn't come. Even then, my lord, our claim is 1/1/2000, claim is with effect from 1/1/2006. And that part was, my lord, accepted by the government. On the basis of that, they filed two affidavits, my lord, on 18/10/2022 and 16/5/2023, saying that since there is a decision taken by the law department by according law vetting, therefore we have nothing to say. Subsequently, my lord, they filed in, my lord, made a prayer before the court that these two affidavits is false. Somebody else, my lord, at their personal interest, they filed the affidavit. Therefore, my lord, we want to file a fresh affidavit. Then they withdrew their, my lord, admission. And whether affidavit once filed can be withdrawn is another aspect of the matter. We also raised this question before single bench. I'll go on this point. Therefore, my lord, the claim remains that our claim is with effect from 1/1/2006. And that is covered by 6 CPC. Now, Lordship, kindly see, my lord, the latter part of the, my lord, observation made by, my lord, HPC. ATA has earlier renounced the claim against the area up to 31/12/2005. Commissioner and Secretary is, as directed by the committee, further negotiate with the ATA. Further negotiate with the ATA to reset the effective date for awarding the benefits of arrears or the fixation or reorganization to 1/1/2009, which too will involve around 610 crores, 610 lakh per annum. The financial involvement will be around 22,000 lakh. If the arrears are paid with effect from 1/1/2009, this amount is huge and will be strained on the state exchequer. The commissioner and the secretary negotiated with the members of the ATA on this account also, and he has reported that ATA would agree to payment of arrears in a phased manner in 4 phases. Now, what is the recommendation, my lord? Recommendation of the HPC, you pay the arrears salary with effect on 1/1/2006 as agreed upon in phase manner. Our suggestion was to pay phase manner. I'm just reading, my lord,
It is
next paragraph.
It is not from 2006. I think it's from 2009, isn't it?
No. They suggested 2009. They said that if it is paid, they said if it is paid with effect from 1/1/2009, then 22 lakhs crores will be the burden of the government.
No, correct. Where is the agreement of paying 2006 from 2006?
Yes, then also kindly see the annexure, my lord, in the.
No, in this minutes, where has been admitted that it will be paid from 2006?
Yes, my lord. What was our claim? What was
No,
our claim?
we are not concerned about your claim, Mr. Purkaisto. We are saying that where is the admitted fact that they have agreed to pay from 2006.
They said, my lord, we have renewed everything.
See, there is a mention of 2009. We can see this, but where is 2006 coming from?
What 2006 coming from annexure 3?
Yes, 220.
Page
But
220.
Where annexer?
Annexure 3.
Page 220.
Annexer 3.
220.
Page 220.
This is our minors. We placed it before the government. Negotiation took place. And
That is,
ultimately, my
Mr.
lord,
Purkaista, that is your claim, that is your
My lord.
minutes. But we are
My lord.
asking where from you are saying that they have agreed to pay you from 2006. There is of
They
course,
did-
there is a mention of 2009.
they did never agree. Ultimately, they have issued the imprint order.
Correct, that I understand. I mean, you are saying that from 2006. From where
Yes.
you are saying from 2006?
And this particular date is in terms of negotiation. This date, I'm reading. The meeting of Central Executive Committee meeting of Arunachal Pradesh Association was held on 21 September 2011 under the chairmanship of Sanso Sanso. The meeting was regarding the pay anomalies of Sanso Sanso. The meeting, after long threadbare discussion, unanimously decided to claim the area from 1/1/2006 and requested the Education Directorate for putting the file on our request to the government for finalization of the above mentioned detail. Roshi is absolutely right. This annexure talks about our decision. Now Roshi has put a question, where is the admission on the part of the government that the claim, my lord, with effect from claim area with effect from 1/1/2006 was accepted by the government. Now Roshi kindly say, my lord. In view of the laws. Well, Roshi kindly says, the page 227. 227 annexure 4. 227 report of the High Power Committee. Have you Roshi got?
Yes.
Hello? 1, 2, 3, 4, 5. From bottom, fifth line from bottom. May I read, my lord? Area benefits from 1498 to 31/12/2005 have already been, my lord, surrendered.
Yes,
I-
surrender, yes.
Surrendered. Therefore, rest is, my lord, still remains. High communication dated 21/9/2022. It is accepted. Government has accepted. That first part was renounced by the ATA. And there is a reference in the High Power Committee that by Annexure 3, 21/9/2021, the first part was renounced and second part remains. Yes.
Okay, got it.
Then, my lord, when the matter was we are under the legitimate expectation that government will provide, and ultimately government issued the notification. 2013, 15 to 2013. All on a shoulder. My lord, then annexure B2. Annexure 2 is the interim notification at page 208. Or 218. 218.
Page.
218.
218.
Annexure 2. This is the imprint order. This imprint order was for the first time challenged before the Writ Court in 2014. This notification, my lord, says that government fixed notional revised benefit, revised Pascal on notional basis, fixed the revised Pascal on notional basis without any monetary benefit. And what is the monetary benefit? Monetary benefit, it was given effect with effect from 1/1/2006. Therefore, we are not entitled the area salary, rather we will be paid the revised Pascal with effect from 1/4/13. And having gone through the entire notification, my lord, there is nothing reflected that in terms of a policy decision government, because their whole stand is that, my lord, in their last affidavit also, which was filed in connection with the writ appeal, they took the positive stand that it is a policy decision of the government. Therefore, whether this particular notification can be construed to be a policy decision. Therefore, my lord, you took a decision, we are not entitled. Now, if we can show that it is a policy decision, assuming that, my lord, they are trying to project. But this benefit was given to many other departments. Annexure, my lord, 1A and 1B. These two documents shows that this benefit was provided to at least deputy commissioner establishment and nursing staffs. And we are, my lord, deprived. They did never say that this benefit was not given to anybody in their affidavit. Therefore, my lord, having gone through this particular notification, impute notification action 2, my lord, from bottom, paragraph 1, 2, from bottom 2, paragraph 2, subparagraph 2, the scale of pay of the appropriate categories of employees will be notionally fixed from 5th CPC stage as adopted in the state with effect from 1/4/1998 under the relevant rules and orders. Actual financial benefits thereon, however, will be tenable from 1/4/2013, that is pay and allowances from the month of April 2013 without arrears. They will enjoy pay fixation benefits only. Therefore, they made a submission, my lord. And I'm sorry to say, they made a submission before the writ court, and that was accepted by the court, saying that everything was paid. If everything was paid, then what is the occasion for the government to issue this notification and say you are not entitled? In 2013. And this notification was, my lord, issued subsequently. Prior to that, Finance Department and, my lord, Education Department, they issued 2 separate notifications. I have annexed in my affidavit, reply affidavit, my lord, before this, filed in connection with the writ appeal. Finance Department says Part B scale is being paid to the Education Department. Finance Department accorded approval. And in pursuance to that notification, my lord, Education Department also issued notification that with effect on 1/1/2006, my lord, this particular, my lord, CPC is adopted.
Where are those?
Yes. My lord, possibly, my lord, affidavit reply is not in the compilation, I think, my lord. Separate affidavit reply in writ appeal. My lord, have you lordship got, my lord?
One second.
Yes.
Affidavit reply file on behalf of the petitioner is there.
Yes, it starts from page 654.
Yes, 654.
Yes, where are those?
Annexure 18 at page 730.
Yes, 724.
750.
Yes, I'm just
750
coming.
is
724.
Oh, yes, my lordship, kindly firstly must see, not Finance Department. No,
Yes,
Education Department. 724 is the motivation issued by state government, Education Department.
724.
24.
Yes.
There is a notification for enhancement.
But in 1990, this is fifth CPC. The Governor of Arunachal Pradesh is pleased to order the enhancement of existing pay scale of the teachers serving government school Arunachal Pradesh as shown below with effect from 1/4/1998. That is 5th CPC. Therefore, the retrospective average is given, my lord, with effect from 1/4/98. And that part was relinquished by ATA considering the financial constraint of the government. We have sacrificed. Now, Lordship, kindly see at page 730.
That this one, this is issued for enhancement of the salary,
Yes, yes. Revised pay scale.
and it was issued prior to your this thing.
Enhancement of existing pay scale. And by the time, yes, by that time, my lord, 5th CPC was adopted. Now, Lordship, kindly see at page 730.
No, you complete your submission. What do you want to show from this?
We want to show that 5th CPC was, my lord, adopted by issuing notification with effect from, my lord, 1/4/98.
But it doesn't speak about any areas.
No, 1/4/98 means, my lord, area. 5th CPC. Because they are supposed to pay area with effect from 1/4/98. We are making our claim with effect from 1/4/98. Therefore, it is implied it talks about the area salary.
Correct. Whether you have challenged this?
Yes, our claim is that, my lord, that they didn't pay. In 2014, by filing petition 21 of 2014, our whole case is that we are denied of our, my lord, area salary with effect from 1/4/98. That matter was remanded back to government. Government, my lord, Secretary of Education then examined the matter and arrived at a, my lord, impugned order by, my lord, a decision on 4/10/2014, saying that due to financial constraints, we are not in a position. There is a stand taken for this. Then also kindly see page 730. 730. That is the Education Department again issued a notification. Governor of Arunachal Pradesh is pleased to, my lord, the Governor of Arunachal Pradesh is pleased to order for implementation of Part B.
Wait a minute. Which page?
730.
Which page you are reading?
730. 730. Annex 18.
Yes.
That is in respect of, my lord, 6th CPC. Governor of Assam, Governor of Arunachal Pradesh is pleased to order for implementation of Part B pay scale of 6th CPC for teachers serving under Government School of Arunachal Pradesh corresponding to 5th CPC with effect from 1/1/2006. Therefore, there is no dispute as to the fact that 6th CPC was implemented, adopted without any modification, allowed with effect from 1/1/2006. Therefore, why should we not be entitled? Government say we are not in a position because of our financial constraint. Government took a policy decision. And thirdly, there is an negotiation with ATA. And ATA, if negotiation ATA is the ground to reject our claim, then negotiation itself shows our claim is with effect from 1/1/2006. ATA never renounced the second part of the claim. And what is the findings of the Honorable Single Judge? Everything was paid. That notification was issued in 2009. Impugned notification was issued in 2013. If everything is
So
paid.
your case is that ATA never renounced this period from 2006.
Yeah,
It has renounced only prior to 2006, that is till 2005. And learned single judges erred in holding that we
Everything
have
was paid.
renounced it. And that's why these affidavits and withdrawal of affidavits happened. That
Yes,
is your case, right?
My case is that, my lord, during the midst of when the matter was pending before High Court, original writ petition, then we have come to know that government has already taken a decision by according law waiting. Then, my lord, we applied for RTI information.
Yes. Anything else?
My lord, Lordship, kindly have a look, my lord, page 735. Annexion
Page?
19, 735. Reply affidavit. Or reply affidavit. Have you Lordship got, my lord?
Yes, yes.
735, this is the notification issued by Finance Department. Therefore, Finance Department issued the notification 13 August 2009, and Education Department issued notice on 8/9/2009. The Finance Department also accorded financial approval concurrence. My lord, I am reading, my lord, in line with implementation of Part B during fifth commission, it has been decided that the proposal for Part B under 6 CPC revised pay scale of teachers of education department and nursing staff of health and family welfare department is approved. In respect of teaching staffs as well as the nursing staffs, they are being paid Part B, and that was accepted by them in their affidavit. Yes, Part B was provided to them, my lord, in while
Mr. Purkasta, one thing.
Aye.
So here in all the notification, it is assistant teacher, junior teacher, and senior teachers are also mentioned. What about the
Well-
other? Whether the junior teacher have been given?
No, nobody
Junior
was given.
teacher, senior teacher in
No,
implement.
and that's why, my lord, they have filed a separate writ petition, which is also on a connected matter.
Okay, the junior
By
teacher and the
association.
senior teacher have also filed.
We are, my lord, this writ petition basically, my lord, elementary school, my lord,
Okay.
primary and
No, my
and
query
upper.
is whether the others in the notification, junior teacher and senior teacher, whether have they been given?
No, nobody was given, my lord, but we are
Are
not
comparing?
representing them.
Okay.
We are not representing them. We are representing only
Okay.
UPA and GPA.
Okay. So what you have anything to submit before admission?
Therefore, my lord, this is the
My lord,
fit case for admission.
yeah,
Looking at admission
I'll
question.
Just a minute. Just a minute. Probably it appears that it will take some time.
Yes.
there is nothing in this case. Your Lordship will kindly
Just a
come.
minute, Mr. Purkasta. Yes.
Let me clarify the position. Your Lordship will kindly take up page 730. He's on affidavit. His affidavit in reply. 730. And the entire Ramayana has been narrated. We are still left wondering who is Ram.
It is not a Ramayan. It is not a Ramayan.
Your Lordship
It is
will,
Ramayan.
I will demonstrate who is Ram just in 2 minutes. Your Lordship will kindly come to page 730.
Yes.
In 730, your Lordship will find fifth CPC in that column. Entry scale, rupees 4,500, 125, 7,000. Your Lordship has seen.
Yes.
So this is the benefit of fifth CPC, which was already given. Now, on in the middle column, your Lordship will find the sixth CPC benefit, 6,500, 10,500. Now, if your Lordship will kindly come to the order impugned, which your Lordship will find at page 218 of the writ appeal. That is why, my lord, it is necessary to insist when a person invokes the writ jurisdiction, it is necessary to insist that you come clean. Page 218. They are claiming the benefit on the basis of this, that they are entitled to arrear salary. Your Lordship will come to the first table, man. Fifth CPC, 4,500, 125, 7,000. That is already granted under fifth CPC. Now, in the right hand side, your Lordship will find sixth CPC, 9,300, etc., etc. If your Lordship comes to table 2, your lordship will find that 4,500, 125, 7,000, that has been further revised to 5,500, 175, 9,000. The reason is that fifth CPC, central government made a recommendation, we adopted Arunachal, and we granted the benefit. Thereafter, the sixth CPC also came. That has also, I can place all those documents. That has been adopted and that benefit granted.
Benefit
Now-
granted from which day?
Right from whenever it was notified in terms of the adoption. Now what happened is very interesting. My learned friend read out the high power committee. He did not read out the most important paragraph. If your lordship comes to the high power committee's report.
Page 222. Page 22, yes. 223, 222,
222.
yes.
They started claiming right at the bottom, your lordship will find a sub-paragraph marked as small a, right at the bottom, at page 222. Non-enforcement of Government of India's OM number so-and-so dated 4/4/2002. Simultaneously in respect of assistant teachers by the state government, and on the same analogy, craft teachers and laboratory attendants being missed teachers having same scale. So what had happened was, they had already got the benefit of 5th CPC. They had also got the benefit of 6th CPC. This Government of India OM came to be issued. That most vital document has been suppressed. Your lordship will not find it in the writ appeal. That your lordship will find in our affidavit in opposition. Entire benefit is claimed on the basis of this 4/4/2002, and that 4/4/2002 itself is not even annexed, either in the writ petition, and they again suppress it in the writ appeal.
So which page?
Page 649. Entire claim of the teachers was that on the basis of this OM, we should be given the added benefit. Page 649. It is an annexure in our affidavit.
No. Your affidavit,
Affidavit in opposition filed by the government.
it's not. No, it may be below.
But I am placing my,
No.
yes,
6?
649.
No, not this one.
It is against this affidavit
Yes,
that they have filed the reply.
Yes, it's there. Yes.
Has my lords got it?
Mm.
649. This is the OM that is being referred to. And your lordship will kindly have a look. Who is this OM applicable to? Subject is, it is addressed to Secretary Andaman and Nicobar, Delhi,
Union territories,
Union Territories. Your lordship will look at the,
not to state of Arunachal Pradesh.
not to state or Arunachal Pradesh. So on the basis of this, they started claiming additional benefit. And it is this benefit that has been given. And
No, we are not claiming.
that too, on the basis of what we were sympathetic to them, and that is why we granted them the benefit. In fact, the higher power committee's report itself clearly mentions this one. And now we have said that, all right, we are giving you this additional benefit, but we are fixing it notionally. In the previous period, you will only get it prospectively, because this is not under the either the 5th CPC or under the 6th CPC. In fact, my lord, this is what we have clearly stated. If your lordship will take up our affidavit for a moment, my lord. Paragraph 4 onwards, we have made the position very clear. And it is, all these aspects have been considered by the learned single judge. Para 4 onwards. my lord. That the 5th central pay, have my lords got it?
Yes. Yes.
That the 5th Central Pay Commission recommendations came to be implemented by the Government of India by notification number so-and-so dated 30/9/97. Subsequently, the Government of Arunachal Pradesh implemented the 5th CPC by notification number so-and-so dated so-and-so. It was followed by another OM number so and so dated so and so, whereby it was clarified that revision of pay scales in respect of government of Arunachal Pradesh, the part A of the first schedule would be applicable. Thus, as per the aforesaid OM dated 2310 to 97, the pay scales as notified in Part B and Part C of the schedule would not be applicable to the government employees of Arunachal Pradesh. It is pertinent to mention herein that prior to implementation of the 5th CPC, the elementary teachers were drawing a pay scale of rupees 1350, etc., etc. Their pay scale was revised under the 5th CPC, and accordingly, elementary teachers were paid at the pay scale of rupees 4,500, 125, 7,000. The senior scale was revised to S9, and they were revised to the pay scale of rupees 5,000 to 8,000. The selection scale was revised to S10 and revised to pay scale of 5,500, 9,000. Therefore, no area salary is pending in respect of primary teachers against the 5th CPC. Now, next paragraph. We have annexed all these notifications. Next paragraph. That after implementing the 5th CPC as mentioned herein above, the government of Arunachal Pradesh had also implemented the recommendation of the 6th CPC by OM number so and so dated 5/1/2009. Accordingly, the pay scale of the elementary teachers under the Education Department, Government of Arunachal Pradesh was again revised as per the 6th CPC and ordered for implementation of Part B pay scale under the 6th CPC for teachers serving under the government schools of Arunachal Pradesh corresponding to 5th Pay Commission with effect from 1/1/2006 wide order number so and so dated 8/9/2009. It is pertinent to mention that all the teachers serving under the Education Department so and so, including elementary teachers, had received the revised pay scale under the 6th CPC as notified by the Education Department by order dated so and so. Hence, no arrears of salary is pending in respect of elementary teachers of Education Department, even under the 6th CPC. And again, we have annexed those notifications. Thereafter, that after having received revised pay scale as per the 5th CPC and the 6th CPC, as mentioned herein above, suddenly an association by the name of Arunachal Teachers Association started demanding revision and enhancement of the pay scale as per Government of India letter number so and so dated 4/4/2002. This is what is meant for union territories. It is pertinent to mention herein that the aforementioned letter dated 4/4/2002 issued by the Government of India was specifically meant for union territories mentioned therein, and as such it was not applicable to the state of Arunachal Pradesh. That in response to such demand of the said Arunachal Teachers Association, after having conducted several meetings and discussions with all stakeholders, and also having considered the financial implications thereof, the government of Arunachal Pradesh took a generous view and decided to accept the request of the said association. Accordingly, the pay scale of the elementary teachers serving under the Education Department, Government of Arunachal Pradesh was revised and refixed by order number so and so dated 15/2/2013. This is the order impugned one issued by the Commissioner of Education, the Government of Arunachal Pradesh, as per revised pay scale fixed by the Government of India wide letter number so and so dated 4/4/2002. Although such pay scale was specifically meant for employees of union territories, Government of India, and not for Government of Arunachal Pradesh. A plain reading of the order dated 15/2/2013 makes it abundantly clear that the concerned teachers were already enjoying the benefits of 5th CPC recommendation, and what was granted by the said order was an additional benefit in terms of the Government of India letter dated so and so. That it is pertinent to mention that since the elementary teachers serving under the Education Department, Government of Arunachal Pradesh had already received their revised pay scale under the 5th CPC and the 6th CPC, therefore, in order to pay them higher pay scale as mentioned in the aforesaid Government of India letter dated so and so, the revised pay scale as mentioned in the aforesaid order dated 15/2/2013 was notionally fixed with effect from 1/4/98 to 31/3/2013, and actual benefit of the revision was granted with effect from 1/4/2013. Accordingly, all the concerned teachers represented by so and so had accepted the revised pay scale as notified by the Education Department so and so dated 15/2/2013. What happened was they played it very smart. They first took the benefit of 5th CPC. Thereafter, in 2009, took the benefit of 6th CPC. As soon as this letter came out pertaining to union territory, they said that since some of the union territories are getting an additional benefit, give it to us also. We took a generous view. We said, all right, we are giving you this additional benefit to make it at par with the union territory. But since it is an additional benefit, we will not give you the arrears. We will give you prospective. So the fundamental thing, whenever a person approaches, a citizen approaches a writ court, what is the first question that your lordship poses? What is your legal right? So here, that is why after making such a lengthy, elaborate argument, the petitioners have not been able to point out where their legal right emerges from. There is no right whatsoever. And these are the aspects, if your lordship sees the judgment, all these aspects have been considered. And in fact, the learned single judge took up on the issue of maintainability, although the learned single judge recorded that there is some force. Since I am deciding on merit, I am not going into it. This is exactly, if your lordship peruses the judgment, your lordship will find that this is exactly what has been recorded. So there's absolutely nothing. In fact, such a mischief was played. One of the beneficiaries, he managed to get the earlier 2 affidavits filed by misleading the director. Then they have been proceeded against, we have initiated proceedings against them. And this, if we are to give this benefit, we'll have to part with not less than 300-400 crores. In a nutshell, my lord, this is the case. Where is the question of, my lord, any relief being granted? In fact, your lordship wants to go into the details, I can place the judgment there also. And your lordship is aware of the law. As the term itself suggests, it is a recommendation by the pay commission that is not even binding on the government. We can accept, yes, in fact, your lordship had already posed that question. So therefore, where is the legal right? And that is why my learned friend has not placed all these notifications. In fact, that impugn notification itself clearly spells out that they have been enjoying the benefit. It is only an additional benefit that was conferred. So how can there be any question of arrears?
My lord, in reply to that, my lord. If my
lordship will find,
Yes.
if your lordship sees, how have they dealt with the affidavit? Our contentions are not, there is no specific denial in the entire reply that has been filed. They have not been, general denial will not do. In any case, well, if your lordship sees the ground, the facts as recorded by the learned single judge are not even disputed. If your lordship so desires, I can place those judgments also, that recommendations of CPC are not even binding. There are a series of judgments. May I suggest this one?
Yes, sir.
Instead of admitting, because the moment why I am resisting the admission is,
Right.
if these kinds of matters are admitted, there is possibility of further mischief at different levels. So your lordship may fix a date at the admission stage itself for disposal. That is one of, that way, my lord.
Yeah, I think that whatever my brother say,
On a hearing date, if it is fixed for final disposal at the.
because we need to go, because it's a bulky document, so we also need some time to go through this.
Yes.
My lord, in reply to whatever submission was made, my lord, in reply to that, I do not understand, my lord. I'm sorry to say that I could not understand. Their whole stand is that everything was paid. If everything was paid, my lord, then lordship kindly see the notification, input notification. I have already pointed out. Last at para 2 from bottom. Scale of pay of so will be normally notionally fixed on ETO with effect from 1498 under so and actual financial benefits thereof will be tenable from 1413. Therefore, benefit they have given, my lord, revised benefit they have given, that was only with effect from 1413. So what about the prior period, my lord? It was given effect from 1/1/2006. so far as 6 CPC is concerned, and you are saying you are entitled to get the revised pay scale with effect on 1/4/13. So what is the question of my lord payment and what is the question of receipt? And what suppression we have made?
So, on that day,
Lordship,
you,
may I-
the appellant should, you come along with the one list of that, short list of that prepared.
Yes,
Yours is a
Yes.
bulky document.
yes. I'll give a short.
Yes.
And already judgment,
then-
sir, my lord, I will cite all judgment in our favor. And court says, my lord, no reason is given. while rejecting our-
Mr. Purkayastha, before parting, I mean, tell me one thing, whether you have got the benefits under 5th and 6th commission or not?
Not good.
No, nothing. They paid the revised pay scale with effect from 1/4/13. Whereas we are
No-
entitled
notification-
from
No,
1/4/98.
revised on the basis of the recommendation of 5th and 6th or something else?
No, 5th CPC with effect from 1/4/98 to 31/3,
See,
2005.
5th CPC was recommended, that was implemented.
My lord.
6th CPC
Not-
was
yes.
recommended, that has been.
And implemented. And they
Correct. Now
have
they have-
given the
now they
benefit
have-
with,
No, listen to me. Now they are saying, that is the government stand, of course, government is saying that in addition to that, something has been paid to you. It's not
no,
as
it
per
is
the recommendation.
absolutely absurd.
Hmm.
Absolutely absurd, madam. We are not going to accept it. What is the question? Notification itself is absolutely clear. You are entitled to get the revised benefit with effect from 1/4/2013. You are not entitled to get any monetary benefits. What does it mean? And if everything is paid, then how do you take the pre-manual policy decision? You are not entitled. How do you say there is a negotiation? You are not entitled.
Policy decision, he's talking about the subsequent enhancement of pay scale. That's what he is saying. That is his submission,
They
of
are
course.
saying government took a
He is
policy
saying that
decision.
you have been given as per the recommendations, but certain additional benefits have been given, actually,
What
which is
what idea
actually
salary?
not for.
Can it be seeking
And
additional
that
benefit?
enhancement they are giving, but they are not giving you areas because that's a policy decision
Yes.
they have taken. That is the
Yes,
step.
that's right, my lord. Yes, absolutely right. My lord, absolutely right. Therefore, policy decision in terms of
So if it is absolutely right, then where is your case?
what is absolutely right? That we have been paid.
No, whatever I have said, you said absolutely right. Then
Absolutely
what
right, my lord.
means?
No, lordship is right to the extent that arrear salary was not paid in terms of policy decision. We are saying we are entitled to arrear salary. Arrear salary means accrued, which accrued with effect from 1/1/2006, 6 CPC, and accrued with effect from 1/4/1998, my lord, 5th CPC.
We
They
have seen
took
the
a decision-
notification whereby you have received the enhancement on implementation of the 5th and 6th.
With effect from which
And it is
date?
only with the,
With effect from which date? 1/4/13.
okay, we'll fix the date then.
Must be fixed. Okay, we'll fix a date.
My lord,
So when do we fix?
my lord,
I have
my
to
lord,
come.
Hard.
my lord, whether lordship is going to keep it as a partner.
No,
No, no.
part hard would be difficult for the division bench.
My lord, yes.
I have to come back for a matter on 20th, madam. If it is this month, it can be on 20th. Or else, my lord, the
20th,
other
I'll be
matter,
out of station.
in
Medical
that case,
treatment,
my
I
lord,
will
the other matter has been fixed. Item number, the thing, has been fixed on 15th of June. This can be also fixed on
15th June.
15th.
Yes.
Okay.
My lord.
Mr. Purkayastha. Lana counsel for the appellant also had Mr. Chaudhary, Advocate General for the state. Stop, Tara. On the request of both the Lana counsel for the parties, list this matter on 15 June, on which date an endeavor shall be made to dispose of the entire matter. Okay.
Your lordship has fixed on 15th.
And I'm like,
15 June.
Obliged.
I'm obliged, Your Lord.
Item number 4.
Madam, the service copies and receive, madam. So I'll take up in this matter, madam, letter course.
This is item 4.
Correspondent number 2 and 3.
Well, appearing on behalf of
Yes.
respondent number 2 and 3. Okay.
meantime, paper book.
Yes, yes. You are for?
For appellant.
Okay, Mr.
Birba.
Land Council for the appellant. Mr. T-Sung, Land Council appear on behalf of the private respondent number 2 and 3.
Yes.
Staff, huh? Since the paper book, sorry, since the trial court record has been received, come on, let the registry. The registry shall prepare a paper book. Stop, huh? List the matter after furnishing a copy of the paper book each to the appellant and the respondents on the date to be fixed by the registry. Okay.
Much of.
Item number 5.
Lordship, this matter may be adjourned because the matter is represented by advocate Monojit Biswas from Guwahati. So he could not appear today. Some date may be fixed after a week.
No. Okay. No objection.
As per the convenience of
Mr.
senior,
20th,
yes,
20th of May. madam.
20th of May.
Okay. Mr. T. Tapak, Land Council submits that the case would be represented by Mr. M.
Monojit Biswas,
Biswas,
yes.
who could not come today, appear today. Accordingly, prayer for listing this matter on
20,
28.
20.
20, okay, 20, yeah. This month.
This month, May.
Okay, to which the Mr. Chaudhary, Land Advocate General, has no objection. Mr. T, okay, Mr. And Mr. For the state, and Mr. T. Togum for the Department of Education has no.
My lord, I'm private respondent, ma'am.
Oh, private respondent?
Yes, ma'am.
Okay. Has no objection. Prayer allowed. Accordingly, list this matter on 20th. Okay.
Obliged.
Oh, it's done. Yes. Yes.
May I please, my lord? My lord, I beg to mention item note 31. No. My lord, matter may be adjourned for 3 weeks, my lord.
What for it has been listed?
My lord, here the counsel is from Guwahati,
Okay.
P. Das. He will be appearing in this case, my lord.
But what for it has been listed in order? Affidavit filed?
No, not yet.
Not yet.
Not any of
For
the
the,
part.
mentioning on behalf of the petitioner.
Yes, my lord.
Okay. Who is for the other side?
Other side, the government is there and the private respondent. I have taken consent, my lord.
Okay. Mr. N. Taje, Land Council submits that in this matter, Mr. P. Das,
P. Das.
Land Council, who is outstation advocate, would be appearing. He could not come today before the court, therefore pray for adjournment. He has also obtained consent from the Land Council for the other side.
Your Lordship, we have
And
not received
praise
the
for
copy, Your
listing
Lordship.
matter after
3 weeks, my lord.
3 weeks.
3 weeks. We have not received the copy.
Okay. The prayer is allowed. Huh? List this matter after 3 weeks. In the meantime, the petitioner shall furnish extra requisite copy to the Learned Council. The Learned Council, government advocate for the state respondent. Okay. Tell him to furnish copy.
Yes,
Okay.
obliged.
Obliged, Your Lordship.
Hmm.
And Your Lordship, item number 9 and 10, Your Lordship. I've taken concern, Your Lordship. This matter to be listed on.
It's exactly not concerned, my lord. On the last occasion, Mr. Nawam said, objected that this will be the last chance. Now he is not here. I don't know. It's a 2015 matter, my lord. I hopefully on the next day, hopefully no further adjournment is taken.
Okay. So this time. So why adjournment? Affidavit filed.
Then it's ready, my lord. 2015 matter, pleadings are complete.
Hmm?
Pleadings are complete.
Pleadings are complete.
Yes. It has actually come for hearing. They have filed an IA. That is why it has been listed here.
Okay. I is for what?
IA, they have alleged that we are carrying out.
Okay. Now, when do you want use?
One
Yeah.
that.
Hmm?
They said 2nd of June.
2nd of June. Okay. So,
This is as per Mr. Tama's convenience.
okay. Yes. We'll fix on 2nd of June then.
My lord.
Okay. Pangoha, Learned Government Advocate. Mr. R.S. Navam will appear.
Yes, Your Lordship.
That in this case, Mr. R.S. Navam, additional AG, will be appearing, who is not in the court today. Therefore, pray for adjournment of the matter to be listed on 2nd of June, to which Mr. Dicky Pange, Learned Senior Counsel, assisted by, has no objection. Assisted by,
Ditamuk.
okay, has no objection. Prayer allowed. List this matter on 2nd. Accordingly, list this matter on 2nd June. Okay.
Obliged, Your Lordship.
My lord, I'm mentioning item number 16 on behalf of Mr. K. Gogoi. Your lordship, we are seeking some more time to file our affidavit in reply. And with the consent of both the parties, your lordship, the matter may be fixed on for 8 June.
Okay. Mr.
Appear on your lordship on behalf of
On behalf of
K. Gogoi.
K. Gogoi, Learned Counsel for the petitioner, prays for some more time to file affidavit in reply. Staff. He also submits that he has obtained consent from the Learned Counsel appearing on behalf of the respondent for listing this matter on 8th June.
Yes, sir.
Okay. Accordingly, he prayed for listing this matter on 8th June. Huh? Accordingly, the prayer is allowed. List this matter on 8th June. Okay.
Obliged, Your Lordship.
My lord, I beg to mention item number 24, 23, my lords. 23, 24, my lords.
24?
Yes, my lord, 23, 24. 23, sir. And my lord, the conducting counsel is out of station due to the problem, my lords.
What for this has been listed?
And my lord, suppose I have to file rejoinder, my lords. And my lord, I will file rejoinder on 27 of this month, my lords.
Okay, Mr. You are Mr.
Tigami, my lord.
Learned Counsel. Your name is there?
Yes, my lord.
Okay, Learned Counsel for the petition. Praise for. When are you filing?
My lord, 27 of this month, my lord.
27?
Yes, my lord.
Okay. Praise for allowing, praise for granting some more time to file affidavit in reply. The prayer is allowed. When do you want this matter to be listed?
27, my lord.
27?
Yes.
You
Yes.
said you are filing on 27.
Yes.
Okay, and on that day, you want this matter to be listed? Okay. Okay, on the, to which Miss, but sir, government advocate has no objection, prayer allowed. As requested, list this matter on 27 of May.
Yes, my lord.
Okay,
Lordship, 27 is holiday.
okay, holiday, we don't sit.
28.
Why you have chosen
my lord,
holiday?
28, my lord.
Hmm?
28, my lord.
28?
Yes, my lord.
Okay. Yes.
Lordship, I would like to mention item number 29, Your Lordship. Lordship, here we have to file affidavit, Your Lordship. Some time may be given, Your Lordship. I've taken the consent.
Okay, Ms. Basar, government advocate. Praise for how much time?
3 weeks, Your Lordship.
Father, 3 weeks time. Praise for and is granted for the 3 weeks time to file affidavit in opposition. List this matter after 3 weeks.
After 3 weeks.
Okay.
Obliged.
My Lordship. Lordship, I beg to mention item number 8, Lordship. On behalf of PD Naya, Lordship. Lordship, the matter may be fixed on 5th of June, Lordship.
Item number
8.
Item 8.
8.
When do you want to say it?
On 5th of June, Lordship.
5th June.
5th, yes.
Okay. Who is for the other side?
Yes, I've taken the consent, Lordship.
Okay. Miss?
No, permission is level. Item 8.
No objection.
Yes, sir.
Okay. Miss?
Embody, Lordship, on behalf of PD Nair.
Okay. Line Council appearing on behalf of Mr. PD Nair. Line Council for the petitioner. Praised for listing this matter on 5th June, to which the Line Council appearing on behalf of the respondent has no objection. Prayer allowed. Accordingly, list it on 5th June. Okay.
Lordship, I beg to mention item number 28 on behalf of A.R. Barwa, leading counsel for the petitioner. Your Lordship, item number 28.
28?
Yes, Your Lordship. On behalf of A.R. Barwa, leading counsel for the petitioner. Your Lordship, he is from the Guwahati. Due to some personal difficulties, he could not appear before this honorable court today.
Why it has been listed for?
It is in orders, Your Lordship.
Yes, in order, but
for filing of affidavit, maybe.
Maybe.
Yes, I'm not sure. And Your Lordship, this matter may be adjourned today and kindly be fixed on 14th of this month.
14?
Yes, Your Lordship.
Have you informed the other side?
Yes, Your Lordship.
Okay, Mr.
Y.N. Tamin.
Leading counsel appearing on behalf of Mr. Who is the leading counsel appearing?
A.R. Barwa, Your Lordship.
His name is also not there?
Yes, Lordship, in Wakalat Nama, his name is there.
Mr. A.R. Barwa. Praise for listing this with the consent of the Learning Council appearing on behalf of the respondent. Praise for listing this matter on 14th of May.
Yes, Your Lordship.
Okay. The prayer is allowed. List it accordingly on 14th. Okay.
Obliged.
May I, Your Lordship?
Yes.
Your Lordship, I beg to mention item number 7, Your Lordship.
Item 7?
Yes, Your Lordship. I have taken the consent, Your Lordship. May it be fixed after 2 weeks, Your Lordship.
Okay, Mr. Rira, Lana Government Advocate, with the consent of the Lana Council for the petitioner. Praise for, when do you want, you said?
After 2 weeks, Your Lordship.
Listing this matter after 2 weeks. Prayer allowed. List this matter after 2 weeks. Okay.
Obliged.
Please pray for her.
Your Lordship, I beg to mention item number 15 on behalf of C. Modi, the leading counsel for the petitioner.
Okay.
Your Lordship, in this matter, actually pleadings were already completed. As per their submission, this matter was listed for admission hearing.
Okay.
And this was taken up on 29th. And today this was again fixed for admission hearing only. But now there...
Has it been admitted?
For admission hearing, Your Lordship, not admitted.
No, that's why pleadings are complete.
Pleadings,
admitted.
As per their submission, yes, pleadings were completed and this matter was listed for admission hearing, Your Lordship.
Okay.
But today they are seeking times for filing rejoinder to our affidavit in oppositions.
Oh, you have filed affidavit in opposition?
Yes, Your Lordship.
Okay.
And now they are seeking time for filing rejoinder, Your Lordship.
Okay.
And I'm seeking urgency, Your Lordship, in this matter because I'm appearing for.
You file rejoinder within one.
Within, yes, sir.
Okay. Miss
Vidya Esther.
Land Council appearing on behalf of Mr. C. Modi, Land Council for the petitioner. Prays for some time. Submits that she has received the affidavit in opposition filed by the respondent and wants 6 times to file affidavit in reply, for which she prays for 1 week.
Yes, Your Lordship.
Prayer is allowed. List this matter after a week.
Lordship, may I pray for fixed date? Can it be on Monday, on 11th of May, Your Lordship? Because this matter pertains to.
Okay. On, we'll say 14th.
14th, Your Lordship.
13th May.
13th May.
Okay.
Much obliged.
May I please, my lord? Lord, I beg to mention item number 25. This matter is first time today listing and after filing of my Bakalatnama. So I, on behalf of respondent, my lord, so I need to file affidavit and I need some more time. Item 25.
Who is for the petitioner? 25?
Yes, item 25, my lord.
Okay. Who is for the
petitioner? Since is from outsider, my lord, so I could not able to contact him.
No, not yet.
Not yet. My lord.
Okay.
Some local
order
name is mentioned, but
wait for some time then. Wait for some time. We'll grant you time, but
All right.
wait for some time.
Right.
Okay.
May I, Your Lordship?
Yes.
Your Lordship, I beg to mention unlisted matter.
What is this about? What is this matter about?
Your Lordship, it is matter about we are challenging the appointment order.
Okay, get listed tomorrow.
Yes, Your Honor.
Okay.
Lordship, I beg to mention item number 30.
Item?
30. On behalf
Highly obliged.
May I pray that this matter may be listed after 3 weeks.
You have informed the petitioner. Okay. Mr.
R2 on behalf of Peter.
Appearing on behalf of Mr. T. Tagong, Land Steering Council Education Department, with the consent of the Land Council for the petitioner, prays for listing this matter on after
3 weeks.
After 3 weeks. The prayer is allowed. List this matter after 3 weeks. Okay.
May Lordship.
Yes.
Long pending matter, Lord, 2020 matter. This is Dumia Bogo versus Desha Bogo. It is a part hard matter, Lordship, before your Lordship bends, Lordship. This matter,
part hard matter.
Yes, part hard matter. It was virtually matter was argument was also over.
What is this matter about?
It is a revision, civil revision, appeal, civil appeal. Second appeal, Lordship.
Second appeal?
Yes.
Part hard?
Yes, part hard.
Okay.
And can this matter be fixed on the 7th?
Are you sure that it is a part hard?
Yes. Argument was almost over, Lordship. Since reply was pending.
Okay. When do you want then?
On 7th, Lordship.
On 7th?
Yes, 7th of May. Lordship. Yep. Today is 4.
Okay. Okay.
Please, Your Lordship, I beg to mention item number 20, 21, and 22. Lordship.
Item?
20, 21, and 22. They are
These are in order?
Yes, Your Lordship. In this Lordship, we have not received our otherwise comment. Lordship. For the
Not yet received?
Yes. Earlier, they used to be standing counsel for land management department. Lordship. Recently, we have taken over.
Who is for the petitioner?
In item number 20, Lordship, I'm for the petitioner also.
Okay.
In item number 21 and 22, I am for the petitioner.
Okay. Ms. Sangita, Land Government Advocate, appearing on behalf of the state respondent, Sami State. See, they are still awaiting the instruction in this regard. Therefore, pray for how much time you said?
3 weeks.
For the 3 weeks time to obtain necessary instruction and also to file affidavit in opposition. Stop, huh? Mr.
K. Loyal.
Land Council for the petitioner in item 20, huh? And Miss
M. Karwat.
in item 21 are also present. Huh? Stop. Age prayed for comma list this matter after 3 weeks. Okay.
Obliged.
Also, Your Lordship, item number 38.
30.
38. 38. In this, Your Lordship, we have received our parawise. We will be filing it. For that, Your Lordship, 3 weeks may be granted.
When do you want you said?
3 weeks, Your Lordship.
Have you informed the petitioner?
Yes, Your Lordship.
Okay. Same Ms. Sangita, Lanet, government advocate for the state respondent submits that she has received Parvaz comment and would be filing affidavit soon. Therefore, press for further 1 week.
3 weeks.
You said that you have received,
Yes.
okay, further 2 weeks time. Taking advantage of his absence. 3 weeks time. Prayer allowed. List this matter after 3 weeks. Okay.
Lordship. In item number 15, Your Lordship, this matter may be, this was adjourned sometime back, Your Lordship. This may be listed in the admission column.
Which one?
Item number 15, Your Lordship, which was adjourned by the petitioner, Your Lordship. It was already adjourned. May I pray that this matter may be listed in the admission column itself, Your Lordship?
This is also in the admission
Yes,
column only?
yes,
Yes, it will be listed in the admission column only.
Yes, Your Lordship. Obliged.
Item 15, huh? For admission hearing, huh? Okay.
Item number 1.
May I please, Your Lordship?
Yes.
Lordship, this is for willful violation of the order passed by the Honorable Court in WPC number, my lord, Annexure 1, 88 of 2025. Order dated, my lord, 19 January 2026, my lord. Wherein it has been clearly mentioned, the operative portion is at page number, my lord, 13, my lord. The petitioners were appointed as constable, civil police, my lord. Thereafter, my lord, the appointment was cancelled, and being agreed by my lord, the cancellation order, my lord, we approached this honorable court, and this honorable court has given a specific direction, my lord. Last portion, my lord. The respondents are directed to forthwith they reinstate the petitioner service in view of the offer of the appointment for the first constable civil police under the sports quota dated so and so, and allow him to undergo the training at police training center PTC Banderdua, Malan. But this was passed in the month of January. Now it's Malan, almost
Okay, say forthwith.
Forthwith, Malan.
Have you?
The other limit has not been given, my lord, but we can institute, my lord, the constitute from the forthwith words. My lord, that has been, my lord, been submitted to the authorities concerned on 27 January, my lord. Next page, page number 14.
Thereafter, you have not submitted any reminder?
No, my lord.
No reply, nothing?
No reply, nothing, my lord. This has been duly received by the, my lord, authority concerned. At page number, my lord, same page 14, just down below, my lord. It has been officially received, my lord. Fully they are aware, despite that, they are not complying with the order passed by this honorable court. Okay. So therefore, this is a clear cut, the willful violation.
Mr. M. Kato, counsel for the petitioner. Stop. Para. This is an application filed under Section 12 of the Contempt of Court Act 1971, read with Article 215 of the Constitution of India and Rule 9 of the Contempt of Court, Guwahati High Court Rules 1977, for non-compliance of
the order dated, judgment and order dated.
Judgment and order dated 19/1/2026, passed by this court in WPC number 88 AP 2025. Staff issue notice returnable by 4 weeks. Staff.
May I pray 2 weeks time maybe. It's because it is only.
Where are they?
It is only in the PSQ, my lord, within this.
PHQ, okay. Returnable by 3 weeks, huh? Okay. Stop, huh? the petitioner shall take steps for notice upon the respondent by a speed post as well as by usual process within 3 days
Malad.
from
Malad, may I pray that Malad, and along with Dusty service, Malad.
Dusty also.
Yes, Malad. That's
Speed will
because
reach, I think, Dusty in the second stage.
no, Malad, just
It
to
will reach.
it will reach Malad, just to expect that Malad, since the office is located within
Why
this.
so urgent? There's no
this
no mention of date also.
Malad.
Anyway, but then of course we could understand it's a fortuit. Okay. On the next date, if it comes back or doesn't receive, then Dusty will be allowed.
Malad.
Okay.
Malad,
At least it's matter after 3 weeks.
termination was done in the year 2025, in the month of February,
25.
Malad. Yes, Malad.
After serving for how many days or how many year?
3 months, almost.
Almost 3 months.
The petitioners were undergoing training for 3
Is
months.
not on any document thereafter, I think.
No, thereafter we have not.
That is why. And then you must have suppressed also at the time of filling up the form.
However, Malad, that has been already Malad decided in this case, Malad. The law is very clear, Malad, to that extent, Malad.
And, okay.
Now, Malad, more than 1 year, Malad, after termination, Malad, the petitioner is nowhere, Malad.
Okay.
That is the whole problem.
Okay.
Much of it.
Yes.
Item number 2.
Malad, in item number 2, before Malad, the start.
Court is not allowing. So senior advocate Mr. Devasis Baruka is appearing, my lord. So kindly, I'm asking the local council to ask somebody to let him join in item number 2, my lord. Yeah.
What do you
May
mean?
please.
Yeah.
Yes.
I beg to appear for the petitioner. This matter, the petition is approached by Lordship seeking protection of life and liberty. The background is that the Union of India for the first time had allotted coal mines.
Anyway, just a minute. The DSGI was directed or asked to obtain instruction.
Exactly, Malad. That's why, Malad, before making submission by the counsel for the petitioner,
yes,
Malad, my submission would be, Malad, this is such a case where, Malad, the proper instruction has to be taken, Malad. As because this provide, Malad, to provide the security, jet plus category security to the Malad, such an individual, Malad, is required to be, Malad.
Then you'll be assessing whether he is entitled for what. But then first of all, you have to assess
Correct,
the
Malad.
situation.
Under which, Malad, the provisions, the guidelines has to be followed. And where is the proper guideline, Malad, when the jet plus security has to be provided in such individual, Malad. Is of course, Malad, he is the chairman of the company. However, Malad, the proper instruction is need to be required, Malad.
At the moment, as an interim, what provision or interim arrangement?
Malad, in such cases, Malad, even interim cannot be, Malad, granted, Malad.
Now,
Once the Malad, the protection is given.
Imminent threat, it appears.
Malad, imminent fact, therefore, Malad, we want to verify from the records that the how threat has been, Malad, caused.
And when do we list it?
May I pray, Malad, within, after a week, Malad, will come with the entire affidavit, Malad.
Okay.
Malad, may I just
let him obtain instruction and then come with an
consideration.
affidavit.
We have placed.
He was not there earlier.
I'm grateful, Malad. I'm grateful. So, yes, Malad, I noticed, in fact, the last time the matter was listed on Friday, that's why the instructions. Malad, may I just submit one thing? We have placed on record the reports of the ID indicating the threat, and my lords have seen on 24th April when he was there in the district, and that's where the ID attack was there and the gunfire. So he had to go back to Delhi only because in order to safeguard himself. So now he cannot really come back to continue with the business. So I borrow to your lordship's directions, but maybe any kind of interim protection so that he can come back and start with the work, my lords. Today he's unable to travel at all in this area, and my lords have seen, I have placed on record the reports. There's a A1 threat, which is indicated by the IB itself. And we have also placed on record the written demands of this militant organization. This is a banned militant organization who have been constantly giving written threats to him about payment of money. I have placed all that, my lords, at Annexure 2 from page 29 onwards. sometimes a demand on 15 lakhs. Kindly see, my lords, page 20.
No, no. So, what happened
Page
whether
29
in
in fact.
Haryana,
So-
what happened in Haryana, whether you were protected? There is a letter.
So, my lords, at present now, yes, my lords. So there's a letter with respect to my residential house at Haryana and then also at
Whether in
Jharkhand. But this
Haryana,
threat of
whether
24th April.
protection has been given to you.
No, Malaj, as of now, it has not been given. In fact, I'm just using my own private security. But my major business is right now in Arunachal Pradesh, where I've been allotted these mines. Therefore, we have approached your lordship, and especially when 24th April, there was an attack. And all these demands are coming really from this banned militant organization from the state matters.
Okay, let him obtain instruction. Okay. Heard Mr. D. Bharuka,
My lords.
Land Senior Counsel, assisted by Mr. A.K. Pandey,
A.K. Pandey, well.
Lordship.
Land Counsel for the petitioner staff. Mr. Kato, Land GI.
Correspondent number 1, my lord.
Would appeared on behalf of appearing on behalf of the the respondent number 1 prays for a seek 1 week time to obtain necessary instruction in this regard and to file appropriate file affidavit. You said affidavit.
We'll try to file affidavit, my lord. If once the instruction we get, my lord, we'll file, my lord.
Okay. Affidavit, huh? If required, huh? And then in this regard, what the state, whether the state is probably state is the one who may have to provide.
That is the one issue, my lord. Or issue, my lord. What are those guidelines, my lord? We have to, my lord, see that also.
Okay, produce on that day. Okay.
It's because, my lord, if the person is within the state of Arunachal Pradesh, my lord, definitely, my lord, the state, the agency will, my lord, give protection, my lord. But he's asking for the, my lord, the jet plus category, my lord.
No, it's not.
Or other, my lord, any other appropriate.
But then,
Page 19
to the extent
yes.
he required.
Or any other, I've also indicated, my lords. Any other.
Mm-hmm.
In that matter, the state is also required to file the affidavit.
And then hard line
Appropriate
also,
security.
Yes. Okay. Also praise for made a similar prayer. Okay. Accordingly, the prayer is allowed. List this matter.
On, my lord, the mayor prayed on 13.
Okay. As requested, list this matter again on 13 May.
May I request for 12th if it is not, if it is 12th, if it can be.
12.
My lord.
Great.
Okay.
Item number 3.
May I sign, my lord?
Yes.
My lord will kindly turn to page number 22, my lord. Annex number 1, page number 22, my lord. This is an advertisement, my lord. Non-ministerial technical examination, my lord. This involves so many posts, my lord. I am concerned with, my lord, head constable, my lord, fire engineer service, my lord.
Okay.
I participated in this selection process, my lord.
Phase?
22, my lord.
22?
22, my lord. This is just advertisement, my lord.
Yes.
I participated in the whole process, my lord. The result, my lord, will find it page number, start from page number, my lord. 27, my lord. Annex number 2, my lord. This is a result, my lord. Final result, my lord. Now, I am concerned with, my lord. We'll see at page number 30, my lord. 30, serial number 8, my lord. Head constable driver, my lord. Post code 1325, my lord. My name, my lord, will find at page number 32 at serial number 36, my lord. Last, my lord.
Yes.
This.
Now, waiting, my lord, for the time being, kindly say the wait, there's a waiting list, my lord. Waiting list, my lord, 1, 2, 3, my lord. General, my lord. Now, in the selection list, my lord, we'll see, my lord, there is as much as starting from, my lord, 4, my lord, up to 36 is APST, my lord. Reserve for APST, my lord. Where? Start from page number 30, my lord. In page number 30, my lord. Start from serial number 4, my lord. This category of the post, my lord, this is APST, my lord. Up to 36, this is all are for APST, my lord. Reservation, my lord. Now, waiting this, my lord, we'll see only category reserve. Waiting this, my lord, will find category general, my lord. There is no APST reserve, my lord. Now, thereafter, my lord, we'll see where corrigendum was issued, my lord, one corrigendum, my lord. Okay. So, my lord will kindly find that at page number 39, my lord. Okay. Oh, sorry, 39. Page number 42, my lord. 42, my lord, will find, my lord. 42, my lord. 4 annexation number 4, my lord. Yes. Now, this coin in person, this coin say, my lord, in person to the corrected medical board report from Prince Hospital, Nalgan, be such and such, the final result in respect of postcode of head constable driver are corrected as under, my lord. Now, earlier, my lord, will recall, I was at 36, my lord. Now, page number 44, my lord. Yes. 36, my lord. My name had been deleted, my lord, from the selection list, my lord. As region is given, my lord, page number 45, my lord. Due to inadvertent typological mistake error in the medical board report submitted by TRIMS medical board in correction to the medical fitness of NMTE 205, the candidate bearing roll number such and such mark as absent by making him disqualify in the final merit list, though the candidate has secured 128 mark in the written examination. Upon receipt of the correct medical report on 23 March 2026, the candidate is placed at serial number 32 in the revised final list in respect of code number such and such. Hereby remove the last candidate, Jitin Tali, that is me, my lord. I have removed, my lord. Now, and wait again, my lord, you see at waiting list, my lord, only general, my lord. Now, I am not concerned with my deletion, my lord. I am saying, my lord, as much as my lord, you see, from 4 to 36 are reserved for APST, my lord. Now, I am saying, my lord, there should be a waiting list from the APST candidate also, my lord. Suppose tomorrow, my lord, out of 4 to 36, suppose one person APST is not join, could not join, my lord. This three candidate, my lord, general candidate could not occupy that place, my lord, post, my lord. Ultimately, there should be waiting list from the APST also, my lord. Now, my lord, we'll see in the result, my lord, there in other post, my lord, they have put the waiting list from the APST also, my lord. Page number 29, my lord, will kindly see, my lord. This is page number 29, my lord. And this is pertaining to, my lord, post, my where this draft mean grade 3, my lord. Sorry, my at page 27, my lord. There is waiting list, my lord, APST, my lord, APST, my lord, 2, my lord, in other post, my lord. Now, it 29 also, my lord, waiting list LMB driver, my lord, APST, waiting category, waiting list, my lord, category APST, my lord. Now, in the case of, in post of driver, my lord, fire and emergency. What is the reservation? Pardon, my lord. What is the reservation policy? What the reservation policy says? The reservation, I believe, my lord, it should be to 80, 20. Okay, so from out of these 36, how many is unreserved? Unreserved is 1 to 3 only, my lord. 3. 1 to 3, my lord. Okay. Unreserved. Now, 4 to 36 is reserved for APST, my lord. Just a minute. So, Kindly see, Mr. Tapi, kindly see page 32, wait list. Yeah. Page 32, wait list. It's category general, general and general. And the total marks is 155. So this, if, how many, out of 36, 3 or 4?
3, my lord.
Three.
As per
Okay.
it is 3, my lord.
Then if that doesn't come under 1, 2, 3,
My lord.
their chance gone.
Gone, my lord.
But why in the wait list? In the entire wait list is a general.
General.
So this probably may.
Lordship, I have spoken to the APSSB. What they say is it's good. As per our this rules of 2018, Rule 16 says how to maintain the working list.
Rule 16. 16.
Rule 16, clause 4.
Okay.
A reserve list or waiting list shall be prepared which could remain names of the candidates equal to 10% of the total vacancies or 2 names of the candidate, whichever is higher in order of merit.
Okay.
So on merit, we have to, because these 2 general candidates, they are 10% out of the total vacancies. They form the merit laws. Therefore, their name replaced. Lordship will find in
Then
that may not be
because unreserved is only 3.
3.
And out of 3, merit from unreserved would be may not be 1 also.
1 also. This sounds something not to me also is sound something not proper.
Yes, yes.
But what this is, it has to be kept as per the merit.
As per the merit of the entire list.
Entire list.
Where can we see the entire list?
It says on merit. When we say merit, then on merit. Merit is basically taken out of the total candidates only.
Then in that case, entire wait list will be these only, even if they doesn't come under those 3 out of 30 or 36. Then the merit list will be, because if they doesn't come within these 3, they fail in the main list. But then automatically, probably, their all unreserved name will come thereafter in the wait list. In that way, if we count that way. I think there is a problem because the unreserved is there also. I think the percentage need to count. Unreserved post, supposing if it is a 10, then 2 wait list. If that doesn't come, 2 from unreserved wait list can come, and rest from the reserve only. It appears. Even if we count that also.
Yeah, suppose say if Lordship turn to page 30, here merit 1 to 4.
Page?
Page 3030.
Of the petition.
The read petition. They occupies the merit that.
Yes, that is why.
Suppose say 3 of them they do not join Lordship for any reason Lordship. Then these people who are in the waiting list, they will be occupying. Because if Lordship turn to next page, that's serial number 5. Marks of the serial number 5, Duli Bagra, is less than the general candidate Lordship. Because up to 4, it's okay, 51, 54.5, which is higher than the marks of the waitlisted candidates. That's 55, 53.5, 142. But suppose say out of these 4 persons Lordship, if 2 persons do not join Lordship, then these other candidates, they cannot occupy that because their marks is lesser than the waitlisted candidates. So then these people will be occupying the seat 1 and 2 Lordship. 2 or 3, whatever. If
no, so see, 1, 2, 3.
Suppose say 1 to 4. 1 to 4 do not.
Up to 4.
Their marks are higher than the
waitlisted.
waitlisted.
Marks are higher.
Close.
And out of this, not 4, out of these 3, because 3 are unreserved. Out
Unreserved.
of these 3, anyone goes, and if the reserved candidate's mark is more than this
5.
serial number
Serial
of
number
4,
5, more than 5.
more than 5,
More than 5.
then 1 or 2, supposing if 1 goes, 1 will occupy.
Close.
Supposing 2 goes, if their marks are more,
More.
they can occupy, but then not below that.
Not below that.
So, but then if 1 goes, 1 supposing doesn't join,
Hmm.
then 2 will become 1, automatically 4 will become 3. They will not get chance.
They will not get chance.
So, but then it appears that the wait list they kept is, I think, not in accordance with
The quota.
yes,
Not as per
not in accordance with the quota, because so these I think probably
So this they
this
have, I
interpretation.
think, interpretations as per their interpretations.
So this probably need to examine, need to be examined.
Notice maybe issue at this.
Okay.
Because this rule 16, it doesn't say from respective quota.
Yes.
So it says merit. When we say merit, merit is out of the total post only, candidates only.
But then automatically
That implies
logic said that logic
that implies that implies.
Okay. Art, Mr. Leasing Permit, Land Counsel for the petitioner. Also had Mr. Staffing, Land Senior Government Advocate for the state respondent.
All the respondents.
All the rest. Okay. State respondent number 1 to
4.
1 to 4. Staffing. Para. We'll say just issue notice. Okay. Issue notice. Returnable by 3 weeks, 2 weeks, or what?
4 weeks.
4 weeks. Okay. Stop. Since Mr. Tapin Lanison Government Advocate appear and accept the notice on behalf of all the respondents, no formal notice need be issued. However, the petitioner shall furnish requisite extra copy to Mr. Tapin within 2 days from today. Okay. List this matter after 4 weeks. Then within 4 weeks, you may have to file affidavit.
Close.
Oh, okay. During which time the respondent shall file their affidavit. Okay. Oh, let's
Item number 4.
May I please, my lord? My lord, this petition is filed by a grieve of the impugn order being passed by Deputy Commissioner, Papumpare District, UP. Lordship, yes, I read out the impugn order, page number 15, my lord. My lord, may they come to page number 15 and excerpt to my lord. Whereas the meeting was, my lord, page number 16, my lord. Page number 16. In compliance with the government order number so and so dated 6 March 2026 regarding page 16, my lord.
Yes, okay.
Page 16, my lord. In compliance with the government order.
Whether implemented already?
Yes, my lord. So because
now you are not running any market.
I'm not running, my lord. Because of this impugn order, I am being deprived because before passing of the impugn order, I'm having valid trading license for running of the.
Yours will be converted to Saturday or what?
I'm running Wednesday market.
Wednesday, but it will
within the market.
You'll be allowed to run market on Saturday then?
My lord, I have been not allowed. So any notification.
Have you made an
any,
application?
No, any notice was issued. Yes, already I on behalf of the.
To allow you to run market on Saturday?
No, my lord. I am not allowing.
Make that because they says that it disturbs because of the administrative difficulties.
My lord, on behalf of the petitioners, the All Arunachal Pradesh Weekly Market Welfare Committee has submitted memorandum to the concerned authorities for consideration of the.
See, they are considering the entire matter because of the infiltration and others and administrative convenience. So they have decided, and this decision is a policy decision considering all those. So now you can only just get it altered that Instead of Wednesday, yours is Wednesday.
Wednesday.
Instead of Wednesday, make it Saturday. You make an application, appropriate application
So
before.
that
the
has been
appropriate
done, my lord.
authority.
That was not been considered. And
No, where is that application?
My lord, I have personally not filed, but
No, then-
on behalf of me, the
Why you allow other
committee
others
has
to
been
file?
filed for reconsideration of the decision.
Where is
made
that?
by- in page number 17, my lord. Committee has been filed before the,
Where relevant to yours is which paragraph?
my lord, this commonly, this representation is submitted before the.
What is the
concerned authorities.
what is the grievance of the common representation?
May I just read out?
Yes.
Representation for reconsideration and revocation of once a week, that is Saturday as the.
You are making for revocation. That may not be. For alteration, have you made?
My lord,
you need to make one application for alteration because
my lord,
one
similar-
day you are allowed that one day, if it cannot be made on Wednesday, it can be altered for Saturday. That is why I'm asking.
my
You
lord,
make a
before-
request.
my lord, before-
Because the place is yours, isn't it?
Yes.
The place is yours. You have a plot of land. You have been granted license
Yes.
to run market on Wednesday. Now, since the government has decided to run on Saturday,
So my lord,
only on
Saturday
Saturday.
market is already existed in my area, my lord. Duimuk.
Okay.
One Saturday
There cannot
market
be
is
two
already,
layer.
yes, my lord.
Ah.
So my place is Rono place. Saturday market is already
that-
existing.
that-
in Duimuk, my
that
lord.
may not
So on
be
the same day, my lord, we cannot run the same daily markets, weekly market, my lord. So while a similar matter has already challenged before this honorable court by the other petitioner, and honorable court has already stayed the order of the deputy commissioner of ICR Itanagar region, my lord.
Which one?
I read petition number 101/26, and then WPC number 163/26.
What it says?
The honorable
same-
court has already stated.
Challenging the same order.
Same, my lord. Only the deputy commissioner ICR region and Papumpare district has passed. So now I am challenging the order of the Papumpare district, my lord, deputy commissioner. So honorable court has already stayed the order of the
Have you
commissioner
annexed
home.
the similar
My lord,
order?
that order I have not annexed. In fact, my lord, I have a copy, my lord. So notice has been issued, and then if I have a copy, then similar order by complying with the
Where is the location?
my place is Rono, my lord. Rono place under Duimuk.
Rono.
So there is already Saturday market is existed, my lord.
Then?
So, my lord, because of this order, without giving any opportunity to hearing, and the deputy commissioner passed order despite he has issue the trading license on regard to the.
Where is the order?
My lord.
But in your case, now you are not running.
My lord,
it will be revival.
Entire Itanagar region, then the ICR Itanagar, they have passed similar order, my lord, by the compliance with the order of the commissioner home, department home. Since last 2022, my lord, I am running that market. So there was no such kind of the illegal activities has been done, and an illegal activity has been found out in my market, my lord, which I am running. We are completely maintaining SOP, my lord.
Yes. What do you say?
Lordship has already observed. Otherwise, is this for the safety of the region only? This has been ordered. Only on the question that if notice was not, personal notices were not issued to them, on that, not only the Honorable Court has given the status.
Here in this case, in your case, notice was issued?
No, no, my lord. No notice was issued despite I'm having valid trading license of Saturday witness day market, my lord.
Now see, the order was passed way back on March. Now it's May. Now, if we allow, means stay means it'll be a revival.
My lord, in my market, some local vendors, they are getting benefit, my lord. So mostly the women, the vendors who are selling vegetables from the local product, my lord. So there was no such kind of incident which the allegation made in the some of organizations on the basis of memorandum submitted before the commissioner home that illegal immigrants. So illegal immigrants is completely checked in my the weekly market, my lord. An allegation also the made that the violation of the inner line permit, my lord. So completely we are properly checking the inner line permit, and then we are maintaining the SOP being provided by the district magistrate, my lord.
General observation. This is general observation by.
So, my lord,
this is a general observation to
the honorable court has
all the
already
markets, because
intervened in the matter.
one is
There
doing
is
on
two.
Wednesday, Saturday, Sunday. That way, whole
Every day
week
there
is-
is a market.
whole
My lord,
week is
in
being
Dimuk, there is only two market weekly, only Wednesday and Saturday, my lord. So Wednesday, which I'm running, so that has been.
There is also Tuesday market.
Yes.
My lord, Tuesday is in different place.
Okay, and Thursday.
And that is in New
Thursday?
Delhi.
Thursday also, every day I think
Only
there is a market
Wednesday and Saturday, my lord, in Dimuk circle, my lord.
in your place.
Yes, my lord. So now my market, because of this order, I have closed down all my the weekly market, and only Saturday is running.
No,
My lord,
it's not,
without giving
not
opportunity.
amounting to close down. Only that you are not collecting the rent only for Wednesday.
My lord, most
Otherwise, Saturday is
women
still,
vendors,
Saturday
local
it is still
residents,
running.
they are getting lots of benefit, and some of unemployed youths, they are properly getting benefit from the weekly
And
market.
there is a report also that taking advantage of this market,
Yes.
people used to bring all those illegal things also.
That
and
was the
sales
yes.
on that day. And because of that, and that caused
my lord-
administrative difficulties. And because
is
of that only, so we should cooperate actually.
So my
When
prayer,
they
my
are
lord,
trying, and an agent, when the normalize come, they come with the proper SOP and on
Yes.
how to control, then probably they will allow again.
so my lord, my prayer is that my lord,
No, at this stage, because it's been more than a month. Stay would be difficult now at this stage. In your case, it will amount to a
my,
revival.
on 10th April, another writ petition was filed by the similar nature.
We'll say that's subject to the outcome of writ petition. Okay.
My lord, the similar nature of
It's not a similar.
order has
because
been stayed, my lord.
it was immediately filed, this case. That is why.
My lord, another matter was moved on 10th of April, my lord. In writ petition number 163/26, my lord. So similar order has been being interfered by this honorable court.
This is interim.
Yes, my lord. Interim has
I'm not
been-
convinced. Then in that case,
My lord, because the order is same by complying with the order of the commissioner whom, my lord. So only the Asia region order has been stayed, my lord. So in my case, I am the lone person who deprived being order passed by the deputy commissioner, my lord.
then I would be the lone judge
So
to deprive you.
my lord, this order may because now I cannot run that market, and then I'm paying regularly that revenue to the state government.
So
my license is still valid, my lord.
heard Mr. Rama, Land Council for the petitioner. Also heard Ms. Jiete, Land Additional Senate Government Advocate, Arunachal Pradesh. Stop para. By this writ petition filed under Article 226, the petitioner has challenged the order dated 6 March 6/3/2026 issued by the respondent number. This was issued by respondent number
3, my lord.
Three.
Commissioner Home, my lord. And then 9
that-
March 26, by compliance of that order, my lord.
Okay, and the consequential compliance order dated 9/3/2026 issued by the Deputy Commissioner of Umpara UPA, by which, whereby the respondent authority has restricted the weekly market to operate only once in a week, that is on Saturday. For Saturday, stop. Only once in a week, that is on Saturday, Okay, stop, It is submitted that the petitioner is the holder of the petitioner claims that he is the holder of trading license issued on dated 7/7/2022 for running a weekly market under the weekly market on Wednesday at Rono Village, Doimuk. Stop. However, by an impugned order dated both 6/3 and 9/3/2026. The respondent authority has restrained to run the weekly market only once in a week, that is on Saturday. It is submitted that the aforesaid order was issued without giving proper notice. Giving an opportunity of being heard to the petitioner, and as such, it violated the fundamental rights of the petitioner guaranteed under Article 19, 1G of the Constitution of India. Stop. Huh? Para. The petitioner submits that in a similar nature of case, this honorable court, while granting notice, has stayed the operation of the impugned order dated 9/3/2026. Well, what happened here in this case? Have you filed any affidavit? Have you filed any affidavit here in this case?
In
Obtain
one of the
instruction?
yeah, in one of the matter, the reply has come.
Okay, what it says?
No, sir, we have just received. I haven't gone through.
Is the government considering
Not
the grievance of the petitioners?
Ah.
Because this business community, they have submitted representation, association.
Yes.
Are they reconsidering the decision?
That lordship,
No, either. So he is praying for similar order.
that can be lordship. They will consider the whole thing. Maybe they will give notices to each one again. Lordship. Because this order is
Okay.
for
However, huh?
commissioner. Lordship,
However,
home commissioner.
Since by after issuance of the impugned order, the petitioner is no longer running the witness market in the said spot. The stay of the impugned order would amount to revival of the market. In view of the above, this court is not inclined to pass any interim order. However, the impugned notification shall be subject to the outcome of this
Yes.
writ petition. Okay, list is
My
matter.
lord, my
2 weeks.
case may be considered, my lord.
Hmm?
My lord, my case may be considered because other vendors now, after relief being granted by honorable court, now they are running properly by maintaining SOP, my lord.
It becomes difficult. See, immediately after the order, now yours stop.
My lord, in my place is a rural area, my lord. But urban area, Itanagar and then usually Naharlagan, they are running, my lord. After honorable court has interviewed the matter, my lord. So my place is in interior, my lord. It's rural area, my lord. So my place, there is no such kind of illegal activities going on, my lord. So because of this order only, I'm being deprived, my lord.
Rural is vulnerable again.
My place is rural area, my lord.
That
So
is
there
more
no such
vulnerable.
maximum vendors are the local residents, my lord. Outsider is not maximum vendors are not outsider from local, my lord. So because of this order, my lord, I'm being deprived. So my lord, till the disposal of matter, my case may be considered and my lord, stay may be granted so that I can run and then some local residents, vendors, they can operate and they can sell their local products, my lord.
Okay. Then issue notice, since Miss at the enter appear an accepted notice on behalf of the state respondent, no formal notice need be issued. However, the petitioner shall furnish extra requisite extra copy to the council to her staff. So notice was not issued. Okay.
No notice was issued, my lord, and no personal hearing was done, and still my trading license is valid, my lord. I'm continuously.
Okay. In the same area, Saturday is running, it probably will not disturb. Otherwise, no, if not, it will not be amounting to a revival. Because in the same area, Saturday market is still running. And if it is a rural, if it is only a rural vendor, can also be protected then in that case, till returnable date. You file the same affidavit, because since already granted in other matters.
Yes.
Okay. Then earlier a similar order that may be kept. It appears that the impugn order restricting the weekly market to one day, that is on Saturday, was passed without giving adequate opportunity to the petitioner and opportunity of being heard to the petitioner. Stuff. Thus, the principle of natural justice appears to have been violated in this case. Stuff. Accordingly, in the interim, and then pending further consideration, the impugn order dated 6/3/2026 and 9/3/2026 shall remain stayed till returnable date.
List after, my lord. My lord, list after.
List is matter after
4 weeks.
4 weeks. Okay.
Deeply.
Item number 5.
May I please, my lord? My lord, by the impugn transfer order dated 28/4/2026, my lord, I have been transferred, my lord, prematurely, my lord, and in my place, my lord, a person, my lord, who is not even born in the cadre was.
There is caveat also.
Yeah, my lord, that caveat may be discharged, my lord. I'm sorry, my lord.
Okay. You are appearing for the caveat. Okay, caveat is then discharged.
May I please, my lord? My lord, by the impugn order dated 28/4/2026, my lord, I have been transferred, my lord, prematurely, my lord, before completion of my tenure, my lord, and in my place, my lord, a person, my lord, who is not even born in the cadre, and he is on probation, my lord, was, my lord, supposed to be brought in, my lord. My lord, kindly peruse, my lord, the impugn order, my lord, is at page 56, my lord.
Hmm. 56.
54, my lord. My name is, my lord, at serial number 5, my lord, Morirwa, DF4 Bandodua.
6 is the incumbent.
And my lord, yes, my lord. Tanitaba, my lord, attached office of DFO Social Forestry FD to DFO Bandodua Forest Division, my lord. My lord, this, my lord, respondent, my lord, who is, my lord, recently promoted, my lord, lordship, I have annexed the promotion order also, my lord. I will come to the rules, my lord, later, my lord. Page 57, my lord.
Oh.
Is the, my lord,
Mr. Saik will continue at 2.
My lord,
okay.
Sorry for
May it please your
lordship,
lordship, my lord. Yes, I'm sorry, my lord.
Yes.
Am I audible, my lord? I'm sorry to
Yes,
trouble
yes,
your
yes.
lordship.
Yes,
I
yes.
know the mention is in the morning. My lord,
Yes,
one
yes.
matter, my learned friend Rotten is there with me. Other side, 36 and 37, my lord. 36 and 37.
Yes.
They, my learned friend Rotten has filed an IA 92 of 2026 for modification of an order that has been passed by this honorable court. If it is not inconvenient, your lordship, may this matter come after a week. If necessary, my lord, we will file an objection if so advised. If so advised,
Okay.
we will file an objection. Otherwise, the matter can come up on 10th, my lord. 10th is Monday. 11th, sorry, my
10th.
lord, 11th.
11.
10th May.
11th.
11 May.
11 May,
May.
my lord. Yes.
Okay. No objection.
No objection.
Okay. Who filed this? I filed.
I filed by the state.
Okay. Okay, Mr. Huh? His name, Lana Senior Counsel. Praise for listing this matter on 11th. And also requested, I requested for listing this matter on 11th and also pray for
Yes.
giving liberty to file objection if necessary in IA.
Yes.
Huh? So which Mr. Okay. Nino, huh? Nino, the Ratan Lanet additional AG appearing on behalf of the state. The applicant has no objection. Prayer allowed. Stop. Age parade, comma. The age requested list is matter on 11th. Okay.
Obliged.
Yes. There is an interim order, my lord. That interim order will continue, my
Okay.
lord.
Then in the the interim order passed earlier shall continue till then. Okay.
Obliged.
I'm
please, Lord,
deeply
sir.
obliged, my lord.
Yes.
Deeply obliged.
May I please, Lordship? Lordship,
Yes.
I beg to mention item 33. Lordship, supposed to be mentioned this morning, but we were late. So, Lordship, this item may be taken up the day after tomorrow, Lordship.
Okay. Yes.
Lordship,
Requested.
I'm sorry, Lordship. 12, Lordship, 12. I'm sorry, Lordship.
Okay.
12.
Item 12.
Yes, Lordship.
Okay. As prayed for by Mr. K. Lolin, not been objected to by Mr. H. Lampolani, counsel for the petition. At least this matter on
Day after tomorrow.
day after tomorrow.
Lordship.
Why day after tomorrow? This is
I have
for admission. Okay.
Yes.
Okay. Day after tomorrow is where? Date 6th. No.
6.
Okay. 6th. Okay. Yes.
Obliged.
I was on my lord, the impugn transfer order, my lord.
Okay. Okay.
The person who was, my lord, to be replaced, my lord, me, is a person, my lord, who is not even born in the Kedar, my lord. Lordship will find it. His promotion order is at page 51, my lord. 57, my lord. May I read, my lord?
57,
my lord.
Okay.
It is dated 25th February 2026. May I read, my lord? On the basis of recommendation of the Departmental Promotion Committee, in its meeting held on 17 February 2026,
Okay, yes.
the Governor of Arunachal Pradesh is pleased to order promotion of the Range Forest Officer to the post of Assistant Conservator Forest. That is entry grade, my lord. My lord, kindly note, my lord, it's an entry grade in the Arunachal Pradesh Forest Service. Sri Tanitaba, he was promoted only on, my lord, 25th February 2026, my lord. And under the rules, my lord, he is on probation for a period of 2 years. And he is not even in the cadre where, my lord, he has been posted now in place of me, my lord.
He's on probation for 2 years.
On 2 years, under the rules. I will come to that rules. On the same set of grievances, and I will say that it's in the same set of harassment. In earlier occasion also, may I narrate the brief fact of the case, my lord. By a transfer order dated 11/2/2024, page 33A, I was transferred from rowing 33A, my lord.
Yes.
I was transferred from I got the transfer order, my lord. A serial number 1, Mori River, DFO Moha Wildlife Sanctuary as a DFO Sagalis Forest Division.
Okay, just a minute. This was
On 14 February 2024. And I joined at Sagali as a DFO, Sagali Forest Division as a DFO. Thereafter, by then, again by a transfer order dated 8/11/2024, my lord will find at page 34. I was transferred again from Sagali Forest Division to Bandodua Forest Division on 8/11/2024. My lord will find at page 34. Serial number 4, Mori River. And thereafter, my lord, again by another transfer order dated 24/12/2024, I was again, after joining at Bandardua, I was retained by a transfer order dated 24/12/2024. I was retained at Sagali Forest Division, reverted back to Sagali Forest Division. Lords, you will find at page 39, page 37.
Yeah, this page 34 is dated.
Page 34 is dated 8/11/2024.
That is 8.
Page 34.
34 is from DFO Sagali to
Bandardua, my lord. For Bandardua Forest Division, my lord. And I joined on 13/12/2024 at Bandardua.
Okay.
By a subsequent transfer order again, 24/12/2024, I was again transferred and retained at Sagali Forest Division. My lord will find at page 37. Serial number 12 is the Mori River petitioner, and at page 38, Gobad, okay.
By this 37, he was retained.
Retained, my lord. Despite joining at Bandardua,
on
my lord, 24/12/2024, my lord.
This is page 37 only. Moro River, DFO Sagali Division, DFO Sagali Forest Division. Retain as DFO Sagali. Yes.
And my lord, in my place, my lord, at that time, at page 38, serial number 15, one Goba Doke, who was also, my lord, entry grade officer, my lord, ACF. My lord, he was also on probation, my lord, was transferred in my place, my lord. Then, my lord, being aggrieved, my lord, by, my lord, this frequent transfer order, I approached this honorable court, my lord, by, my lord, read petition 76 of 2025, my lord. Page 41, my lord.
Yes.
At page 42 onward, my lord. May I read some paragraphs, my lord?
Relevant.
Yes, my lord. Paragraph 3 onward, 3, my lord.
Okay.
The petitioner herein claims to be a selection grade officer, my lord, I am, my lord. Arunachal Forest Office currently holding the post of Deputy Conservator of Forest. Pursuant to an order dated 14/2/2024, the petitioner was transferred from Office of Divisional Forest Officer, DFO Mahua Mehao, to Office of the DFO Sagali, where he duly joined his new place of posting at Sagali. Subsequently, by an order dated 8/11/2024, petitioner was again transferred from Sagali Forest Division to Bandardua Forest Division. The petitioner claims to have joined at his new place of posting at Bandardua on 13/12/2024. However, by the impugned order dated 24/12/2024, the earlier order was modified and petitioner was directed to be retained at his previous posting in Sagali. By the said order, that the respondent number 3 at serial number 15 was transferred to Bandardua. Further, serial number 19, it was clarified that the said respondent number 3 would join the post at Bandardua after retirement of incumbent holding the post, namely Sri T.T. Tapu, who was scheduled to be superannuated on 28/2/2025. The petitioner, being agreed by the aforesaid, had submitted a representation on such and such, followed by approaching this court for the first time by filing. Prior to this, I filed a writ petition also, before also, 58/2025. This court by order dated 5/2/2025, while issuing notice that pass an order of status quo, the aforesaid writ petition has come up for further consideration on 14/2/2025, when the same was disposed of by directing consideration and disposal of the representative. This court had, however, observed that till such disposal order of status quo would be maintained. Pursuant thereto, by second impugn order dated 21/2/2025, representation submitted by petitioner was rejected. This was, my lord, put to this writ petition, my lord, the rejection of the representation, my lord. Paragraph 5, my lord. My lord, come paragraph 6, my lord.
Yes.
Such and such counsel for the petitioner submits that the impugn order of transfer dated 24/12/2025 is in violation of the statutory provisions, my lord, governing service condition, and has been passed only to extend undue favor to respondent number 3 by drawing attention of this court to Arunachal Pradesh Forest Service Rules 2019. In short, rule of 2019, the learned counsel has to refer Rule 3.2, which lays down, my lord, may kindly note these rules, my lord, which lays down that there would be 4 grades in the service. He further refers to Rule 2H, which mandates that constitution of Departmental Promotion Committee for both promotion and confirmation of service. He has also referred to Rule 24, which provides that confirmation in service shall be undertaken by a duly constituted Departmental Promotion Committee in conformity with Rule 14 of the said Rules 2019. Reference is also being made to Rule 5, which lays down method of recruitment as per which there is a quota of 50% by promotion and 50% by direct recruitment. He contended that the office at the Bandardua is to be headed by additional Deputy Conservator of Forest, ADCF, and in this regard, he has drawn the attention of this court to the schedule of the post laid down in the said cadre. I will come to these schedules also, my lord. 7, my lord. The further submit that by order dated the respondent number was promoted from the post of range forest officer to assistant conservator of forest. In that case also, my lord, the respondent in that case was, my lord, promoted from range forest officer.
So the similar case here, right?
Similar case, my lord. Exactly similar, my lord. And the said promotion for a probation of 2 years, which is to be followed by a confirmation of service. He has reiterated that such confirmation would be done as per Rule 24, read with Rule 14 of the said rules of this 2019. Submitted that on date of issuance of the impugn order dated 24/12/2024, respondent number 3 was still in probation period as a ACF, in which otherwise also in lower grade to the post of DCF held by the petitioner. Same situation, my lord.
Now the present incumbent is also ACF.
ACF, my lord, entry grade. I am, my lord, Deputy Conservator of Forest, my lord.
Okay, DCF.
Yes, my lord.
So it's a post of DCF.
Post of DCF, my lord. It's a earmark for the
not
post.
for the ACF or the anti-grade.
Yes, my lord.
Who are in the probation.
Yes, my lord. And accordingly, my lord, this the impugn transfer order has been, my lord, set aside, my lord.
Okay.
At, my lord, lordship will find at page 51 at paragraph 19, my lord. May I read, my lord?
Just a minute, huh? Mhm.
Page 51, my lord. Paragraph
51.
19, 51, my lord.
Okay.
Internal page is 11.
Yes.
May I read? Paragraph 19. In the conspectus of the aforesaid discussion and also taking into account the respondent number 3 was not even in the cadre of the petitioner, and the post where the petitioner was transferred by order dated 18/11/2024 is not in the cadre where respondent number 3 is performing. Same situation, my lord. Namely, Assistant Conservator of Forest. This court is of the considered opinion that the impugn action of the respondent authority is unsustainable in the eyes of law, in connection reference may be made to a judgment of this court passed in Hibutama versus State of AP and others reported in 2021 1 GLR, when in similar circumstances the transfer order was found illegal and interfered with. It is also mentioned that in the aforesaid case, Hibutama reference to many earlier cases were also made, including the order dated 28/9/2006 passed in WPG such and such Sri Niapung Konya versus State of Arunachal Pradesh. In view of the discussions and the writ petition is allowed and the impugn order dated 24/12/2024 and 21/2/2025. 21/2/2025 is the, my lord, disposal of the representation, my lord, rejecting my prayer, my lord, are set aside. Consequently, the respondent authorities are here directed to allow the petitioners to discharge his duties in the office of Divisional Forest Officer, DFO Bandardua, in accordance with law. My lord, accordingly, my lord, the writ petition has been disposed of, setting aside the earlier impugn order, my lord. Pursuant to the order passed by this honorable court, lordship will find at page 53, my lord, by an order dated, my lord, my lord, 12, my lord, 6/2025, my lord, I was allowed to hold the charge, my lord. In compliance of the married, my lord, in compliance of the order of the Honorable Guwahati High Court, Itanagar bench dated 19/5/2025, in the matter of WPC 76 AP 2025, Sri Mori Riba versus State of Arunachal Pradesh, Sri Mori Riba is hereby directed to take over the charge of DFO Bandardua Division with immediate effect. Further, Sri Goba, respondent in that case, is attached to the office of CCF, such and such, my lord. And my lord, only after the order passed by this honorable court
charge as a
DFO Bandardua Forest Division. Yes, my lord. And thereafter, my lord, this impugn order has been passed again, the present impugn order, my lord, on same set of, my lord, facts, my lord. And herein also, my lord,
Not even 1 year.
not even 1 year, my lord.
Okay.
And my same set of, my lord, on facts, my lord, I'm being replaced by a person, my lord, who is, my lord, recently promoted to the post of, my lord, my lord, Assistant Conservator of Forest, which is a anti-grade of the Arunachal Pradesh Forest Service, my lord.
Okay.
My lord, he has hardly, my lord, 1 month, my lord, he was posted in my place, my lord. He is not even born in the cadre of the, my lord, scheduled, in the scheduled cadre.
What is the present position?
Present position, my lord. But I have not been released from the said post, my
not
lord.
yet.
Yet to be, my lord. My lord, now come to the, my rules, my lord. This is the statutory rules, my lord. Page, my lord, 59, my lord. My lord, definitions, my lord, page 59. Rule 2, sub-rule G. The duty post means any post is specified in the schedule, my lord. My lord, kindly, my lord, before that, my lord, again, my lord, rule 3, kindly peruse, my lord. Constitution of service and its classification, my lord. This shall be constituted a state forest service to be known as Arunachal Pradesh State Forest Service. The service shall have the following 4 grades, namely, my lord, in 4 grades, my lord, there are cadres, my lord. Entry grade, that is the ACF, my lord. Senior grade, selection grade, administrative grade, my lord. I am at, my lord, selection grade officer, my lord. And he is, my lord, entry grade officer, ACF, that too on probation, my lord. My lord, then, my lord, come kindly see, my lord, next page, my lord. Rule 5, my lord, method of recruitment, my lord. Sub-rule 2, my lord, Roman 2, my lord. Remaining 50% of substantive vacancies shall be filled up by promotion on the basis of selection in a manner specified in Part 5. The officers who are subsequently holding post of forest, range forest officer, Group B, and possesses such and such qualification in from a recognized university, provided the post actually filled by, my lord. These are, my lord, the method of recruitment, my lord, 50% by promotion, my lord. And next rule, my lord, kindly see, my lord. If, my lord, rule 14, my lord, to promote, my lord, under Rule 5.2, my lord, there has to be a DPC, my lord, as stipulated under Rule 4, page 60, Rule 14, page 62, my lord. There has to be a departmental promotion committee, my lord.
But you are not, since you are not challenging the promotion, his promotion.
No, just to show, my lord, that, my lord, he is on probation, my lord.
Okay.
My lord, kindly say, after the promotion, my lord, he is on, my lord, probation, my lord. Rule 21, my lord.
21.
My lord.
What is Rule 14, departmental promotion? Okay.
My lord, Rule
21.
21, my lord.
Okay.
Period of probation, my lord.
Okay.
My lord, every person appointed under Rule 5, my lord. Here, my lord, he is appointed under Rule 5, my lord, promotion, my lord. To the Arunachal Forest Service entry grade in the service, he shall be on provision as below, my lord. My lord, he will be, my lord, covered by clause B, my lord, subclause B, my lord. Officer appointed to the service by promotion from range forest officer will be on provision for a period of 2 years, my lord. My lord has already seen, my lord, his promotion order, my lord, dated 15/2/2026. He was promoted to the post of ACF, my lord, entry grade, my lord. 25/2/2026, my lord. PS 57, my lord. And he is, my lord, on probation for a period of 2 years, my lord. And the probation, my lord, period has to be confirmed by, my lord, DPC, my lord, under the Rule 24, my lord. My lord, for a moment, my lord, kindly see Rule 24 at page 64, my lord. May I read, my lord?
Confirmation.
Rule 24. A person who is declared to have satisfactorily completed his/her probation period may be confirmed in the service by Departmental Promotion Committee prescribed under Rule 14, my lord. The probation period has to be, my lord, confirmed, my lord. Then only he will be regarded as a, my lord, regular cadre in regular cadre, my lord. My lord, now kindly see the, my lord, scheduled, my lord, post, my lord. At page 67, my lord.
Yes.
First schedule is the, my lord, officers, my lord, of, my lord, administrative grade, my lord. They can hold this post, my lord. Second is, my lord, selection grade, my lord. And third is, my lord, the, my lord, C, my lord, grade, my lord. The post under additional deputy conservator of forest as attached officer in various forest divisions. My lord, now we are concerned, my lord, the Bandardua Forest Division. The Bandardua Forest Division is meant to be meant by, my lord, not below the rank of, my lord, additional deputy conservator of forest, my lord. These are the posts to be meant by, my lord, deputy conservator of forest, my lord. And, my lord, where, my lord, the assistant conservator of forest can be posted, my lord. Lordship will see at D, my lord. Below, my lord. The post under assistant conservator of forest entry grade as attached officer in various forest division as under, my lord. In this, my lord, scheduled post, my lord, he can be posted, my lord, as a attached officer, my lord, including, my lord, DFO, my lord. In group C post, my lord, the scheduled cadres, my lord, the entry grade cannot be posted, my lord.
Yes.
This has been, my lord, upheld in, my lord, the judgment, my lord, in previous round of my litigation, my lord.
Okay.
On the same, my lord, set of harassment, my lord, I am again transferred, my lord. And in place of me, my lord, an officer who is not even born in the cadre was posted, my lord.
Okay.
At this stage, my lord, may I pray that notice may be issued and the, my lord, interim order may be, in the interim, my lord, the operation of the impugned order may be suspended, my lord. A similar order, my lord. It is a covered case, my lord.
Notice can be issued?
Notice can be issued, Lordship. So
Okay.
for interim is concerned, Lordship, that we have objection, Lordship.
What objection?
Here, Lordship, basically as a matter of law, Lordship, the petitioner has to stand on his own merit, Lordship, not on the demerit of the other person, Lordship. Where he is,
that is true, of course.
Where he is being posted, transferred, whether that prejudice the petitioner or not, that has to be seen. If Lordship see, here there's a guideline, even the guidelines 2 years is not completed, that also has been taken as a ground lordship. If lordship come to that ground lordship, I'll firstly clarify. If lordship see the page 70, this is a circular or transfer posting guideline policy of the state government.
Yes.
Kindly come to lordship page 70, condition number D lordship. Here the case of the petitioner is that within 1 year he's going to retire lordship. Officers are not to be transferred 1 year before the retirement, as it may affect preparations of their pension paper, etc. However, generally officers posted in the field oblique work division should be posted out to the office headquarters 1 year prior, so and so and so. Now, where the petitioner is being transferred now? Because for the convenience of the employee only, officer only, he has to be transferred to the headquarters. Exactly what action has been, what has been done in present case also. He has been brought from the division to Itanagar, the PCCF office. Page 54 lawsuit, the impugn order. This is not a selective transfer. Someone has been picked up and transfer lawsuit. This is general transfer order lawsuit. At serial number 5, the name of the petitioners appears. Here lawsuit DAPO, Division Police Officer, Bandadua Police Division. He has been transferred from DCF Industry, which is in lawsuit headquarters itself lawsuit. The PCF office Itanagar, 0.29 lawsuit. Now he is, as per the guidelines lawsuit, he is being brought back to the lawsuit head office for convenience of the petitioner only lawsuit. That one part lawsuit. And second part lawsuit, as I've submitted lawsuit, the petitioner has to stand on its own merit lawsuit. Now we have to see whether by impugn order, how the public service career of the petitioner is going to be affected or not. There are many lawsuit, divisional office lawsuit, where no one is there lawsuit. Suppose say he is being transferred to the place where no one is there lawsuit.
Where no?
Here lawsuit, suppose say no one is being brought in the place of the petitioner lawsuit. For example, the private respondent number 3 is not their lawsuit. Then what is the ground of the petitioner lawsuit? It may happen also lawsuit. Not necessarily someone will be brought in place of the petitioner lawsuit. If there's a shortage of officer, definitely no one will be brought lawsuit. But the petitioner can be transferred anywhere to any analogous post lawsuit, as given in the list in the schedule. Now he is being transferred to as a DCF industry. This particular post is to be manned by the lawsuit. And
So the ground that he is retiring is no longer the genuine ground, according to you.
Lawsuit.
It is for his convenience.
It is one of the ground, my lord. It is not many of the ground, my lord.
Okay. So what do you say about this?
Lawsuit, as per
The respondent has been brought.
Lawsuit
is under schedule.
Therefore, lawsuit, my submission is there, lawsuit. As per the schedule, it's page 67, lawsuit. This particular post, DCF industry lawsuit, that it has to be manned by the lawsuit selection grade lawsuit.
Wait. C. Schedule C.
Lawsuit, page 67.
Okay.
The petitioner belongs to lawsuit this B.
Oh, B, he belongs to B.
Post under deputy
Okay.
conservative police
The-
selection grade.
Okay, the DFO belongs to C.
Group selection grade.
Hmm.
He belongs to selection grade lawship.
Okay.
Selection grade lawship.
Hmm.
And what I'm submitting is DCF industry. This particular post is to be made by the lawship selection grade lawship. The petitioner is being posted or transferred to the post which is lawship in consonance with the grade of the petitioner lawship, the selection grade lawship. So petitioner is not going to be prejudiced at any manner in his service career lawsuit.
Hmm.
That part has to be seen. Now, after he has gone to the lawsuit, gone as a DCF industry, who has been brought at Bandudo or not, that lawsuit is not lawsuit the issue to my legal understanding lawsuit. Though some judgments are there lawsuit, but that also has been diluted by the subsequent judgment of the division bench of this Honorable Court.
He has been brought and then allowed to hold the charge only in the February.
So for transfer posting is concerned lawsuit. Even in 1 month, he can be transferred. But question is the public interest lawsuit.
See, after passing order by this court protecting him, why he had to be transferred?
Lawsuit,
so showing that something else it appears. But then of course it's not his case.
Lawsuit.
But why he should be?
Once he has been brought at Bandudo lawsuit, he was there only lawsuit. For some public interest, he can be transferred again lawsuit.
Right, that is true.
That's the law.
Anyway,
so my submission is so far.
But then once he is released, then the case will no longer survive.
Lawsuit,
it will become infructuous.
Definitely lawsuit. Now that's what.
You have filed representation also.
Yes, yes. That's what lawsuit I'm submitting lawsuit. He has to see whether he is being posted or transferred to the analogous post or not lawsuit. That part only has to say lawsuit. Whether when he is placed in that particular post, whether it affects the service career of the petitioner or not. How the petitioner is prejudiced lawsuit. As I've submitted, he has to stand on his own merit lawsuit. Not the demerit of the other persons who is being brought.
That is otherwise true. That is true otherwise. But
and that part also
but repeatedly, whether this is this kind of a frequent transfer is happening in the department normally.
Normally it happens
because within a year.
Within a month also lawsuit they can be transferred 2-3 times.
But then why this person repeatedly earlier 14 2 24 then 8 11 24 then 24 12 24
and ultimately court has to intervene, my lord.
Now seems something maybe difficulties with the petition. But then
that Malapati is not the ground.
That is not his case.
Malapati is not the ground here.
That is not his case.
Because for Malapati also someone has to be implicated in his personal capacity lawsuit. So
you have submitted submitted representation.
Yes, my lord.
Putting forward your grievances.
Right.
Let the representation be disposed of then.
Yes, my lord.
Until then, he will be protected.
Yes, my lord.
I am appearing for the respondent. I am for the mediator.
Your case, I have understood it appears.
To the disposal of the representation as such, I'm not. I have no objection, madam. I'm just objecting to the interim protection. That my lord is rightly said. Of course, there might be cases of frequent transfer, and as rightly said by my brother, the senior government advocate, there are instances where a petitioner or an employee, government employee, can be transferred within 1 day also. There can be no quarrel with the basic principles of the law, service or transfer of the employee. What the basic crux, what has been urged here in this petition is that a person of a lower grade is replacing him. That is his basic case. Otherwise, that the transfer guidelines, which is also here, where the petitioner.
No, the question here it appears from to the court that since he has been frequently subjected to transfer within a year 4 times, this is the 4th one it appears since last
That
part of
is not even his
2024.
case, my lord.
And then he has been protected by the court. Despite of court being protected thereafter, and he has been replaced by you, who is still under probation.
My lord. That things, my lord, I will bring, my lord, clarify, my lord.
Okay.
Because it is not the case of the petitioner that he has been frequently transferred or there is some malafide intention. That is not the case.
But what?
His only case is basically two issues, my lord.
Yes.
Firstly is that he is being replaced by somebody who is not qualified. That is first case. And secondly, he has been transferred within the 1 year of his retirement. Now that, if you lordship would come to transfer guidelines that as pointed out by learned senior government, it is his on the verge of retirement. He has been brought to the headquarters, man. There's nothing wrong with that. Now, basically, what has been urged on is the my capacity, man, to hold the post of the DFO in his place. That is what has been urged, man. Now that in the earlier case also, in this WPC 76, where some certain orders were passed in his favor, certain facts were not brought before this honorable court. Those things I would like to bring, my lord. Here, my lord, whether even the petitioner was qualified, my lord, to hold those posts. These are things, my lord, I'd like to point out. Firstly, my lord, passing this order, my lord, that WPC 76, my lord, in the first round of litigation, my lord, is another litigation. Reliance has been placed on this Hebutama, my lord. That person of a lower rank cannot take his place, my lord. But to my very, my lord, respectful submission and understanding, my lord, this, my lord, is a wrong order, my lord. Time and again, my lord, right from the S.L. Abbas, things, Govardhan Lal, etc., Rajendra Singh, my lord, it has been said, my lord, until and unless the status of the employee is not changed, or their transfer is in violation of some statutory provisions, my lord, transfer cannot be interfered with, my lord. Now, Supreme Court has also said, my lord, that the status of a person who are being transferred, interstate transfer, my lord, that cannot be looked into by the High Court. Firstly, my lord, I will bring that, take your lordship to that judgment, my lord. Before that, my lord, I would just like to appraise this.
This is me. Then he also doesn't have any right to hold that post, my lord. Being he is not competent enough to hold that post, my lord, under the rules, my lord. But my lord has what proposed, my lord, to dispose of the representation, my lord. Till then,
I'm objecting to the. This is my lord. I have already been released and then I have already joined, my lord. Okay. I've already joined, my lord. Now, my lord, that
where?
At Bandardwa, my lord. Those are my release order and joining order.
Whether the petitioner has been released?
No, my lord.
That I have no instruction.
My lord, he is presently posted at Bandodua itself, my lord.
Who?
But the respondent not free, my lord.
No, my lord, that's I have taken charge, my lord.
Taken charge
I have joined, my lord.
DFO?
DFO, my lord.
Unilaterally, he is there, still there.
My lord.
He is still there.
My lord, since he is not handing over, my lord. I have not taken charge as such. That instruction I do not, but I have joined, my lord. I have joined, my lord.
To whom you are to report?
It is to the, your lordship will see. But these are facts, my lord, that just to the DFO itself, my lord.
Oh, this seems problem.
My lord. Just
such forceful things are happening in Arunachal Pradesh. It's very difficult.
My lord will just go on the basis of the argument that has been advanced, my lord.
Oh, the officers are also colleagues. Released from the establishment.
This is just a factual aspect, my lord. Now coming to the issue, my lord, whether
Authority by issuing such untimely order just out of this case and make the officers to fight with each other. Compel. It's very difficult. Okay, what I'll do, I've heard you. I'll dispose of the matter, okay, in the motion stage itself. What I'll do is give some time. Immediately let the authority dispose of his representation within 1 day or 2 days, whatever may be. But then dispose of, let him dispose of. Okay, till then I'll protect him.
that is what I'm objecting to, because
No, that order I'm
because
going
my
to
lord, this I am also relying on the judgment, my lord, which your lordship was a part of, my lord,
pass.
in the division bench, Taban Tabing, my lord, where these things were distinguished, my lord. When if your lordship will come to the judgment, my lord.
Is this the one?
Yes, my lord. I have otherwise given two, my lord. First is it's WA 2360, my lord, of 2016. That's single page order, my lord.
What
That,
it
my lord,
says?
Hibu Tama, my lord. That had heavily relied on the
Yes, that.
yes, my
of
lord.
course.
That judgment, my lord, in the Nyapung Konya case, my lord. Here, my lord, in this, when this appeal was preferred, my lord, that if your lordship will see, my lord, down below, my lord, the second last paragraph, my lord.
Yeah.
This Rajendra Singh has been, my lord, quoted, man. When we examine the ratio of Rajendra Singh versus state of Uttar Pradesh reported in so and so, it appears to us that the learned court entered into a domain not reserved for the writ court in scrutinizing the validity of a transfer order by referring to the status of the incumbent brought on transfer. It is really for the employer to decide on the transfer and posting and how best the works can be executed. And in this circumstance, we feel that the case is made out by the appellant for admission, my lord. That, in fact, that case was this was the observation of the division bench, my lord. And secondly, my lord, this is writ appeal 21 of 2025, my lord, where your lordship was a part, my lord. Just I want to bring certain fact, my lord. If your lordship would come to paragraph 5 and 6, my lord, because the learned single judge, my lord, did not interfere.
Yes.
So accordingly, your lordship would come to page 3, paragraph 5. My lord is there. Paragraph 5.
Yes.
Assailing the order dated 6/5/2025, Mr. P.D. Nair, learned counsel for the appellant, strenuously submits that the learned single judges failed to consider the ground which the appellant has taken, particularly that the appellant cannot be replaced by a junior officer. In other words, the appellant being a regular executive and the respondent number 3, whose substantive post is assistant engineer, cannot be transferred in place of the appellant, who is a regular executive engineer in the department. Next paragraph. In support of his submission, Mr. So-and-so has placed reliance on the judgment and order in the cases of so-and-so, WPC 257 and so, and Hibutama so-and-so reported instance, and this one, my lord, the Mori River versus State of Arunachal Pradesh, WPC 76, my lord.
Yes, yes.
Now your lordships have replied in paragraph 19, my lord. 19 onwards, my lord, but just I will read paragraph 19, my lord. Perusal of the above judgments of the learned single benches of this court sources, the learned single benches have held that it is not permissible to make interstate transfer between officers who are not similarly placed officers in the department. Having perused the judgments, we are of the view that it may be correct that normally it may not be permissible to make interstate transfer between officers who are not similarly placed officers in the department. However, there would not be a complete bar to transfer an officer serving on in charge officiating or functional in a higher post unless it has caused any prejudice and effect to the service conditions of the officer who is sought to be transferred to a different place of posting within the same rank, status, and benefits depending on administrative exigence. It is true that the higher officer cannot be replaced by a junior officer who may not be competent to work in the said post. However, in the given scenario, if the officer is competent, having the knowledge and experience with his considerable rank of service, in our view, there would not be a bar on such transfer and posting. In the present case, there is nothing on record to show that the junior officer who has been allowed to serve as in charge in the higher post for a considerable time cannot be allowed to serve as in charge of that post, considering the service experience of the junior officer which may have gained in the course of service. and it goes up to my lord para 24. Your lordship was part of the judgment, and the writ appeal was also.
And that is, of course, lookout
Yes,
of the
my lord.
authority only. Of
So, my lord, this there is this, my lord, that Hivutama, my lord, that has been distinguished, my lord. And there's another aspect, my lord. If your lordship would come once again to the schedule, my lord, of the writ petition, my lord, at page 67, my lord.
Yes.
B, my lord. If your lordship would say a post under the DCF selection grade, my lord, to which the petitioner belongs. It's a total of 13 posts, my lord. My lord will see the post, my lord, where the DCF can hold the post of DFO, my lord. Bandardua is not here, my lord. And why, my lord? Because it is an IFS cadre post, my lord. My lord, you see, there's a conspicuously, my lord, that Bandardua, my lord, DFO post is missing, my lord, from the post under the DCF selection grade, my lord, 13 posts. Now, my lord, this is a gadget publication, my lord. If your lordship may come directly to, because the first part is in Hindi, your lordship may come to page 7, internal page 7.
Yes.
This is its IFS, my lord, fixation of cadre strength regulation, my lord. Amendment was made in 2022, my lord. Now, if your lordship would come to next page, my lord. My lord is there. These regulations may be called the Indian Forest Service Fixation of Cadre Strength Amendment Regulations 2022. They shall be deemed to have come into force from on the 7th day of January 2021. Serial number 2, and then it is for the Agmut cadres, my lord, Arunachal Pradesh, Goa, Mizoram, and Union Territories.
Yes.
If your lordship would come to down below, man, on the same page, my lord, page 8. This is Deputy Conservator of Forest, my lord.
Yes.
Namely Namsai, Roing, Jairampur, Diomali, Bandardua, Teju, Pasigat, Bomdila, Along, Hapoli, and Tawang. These are to be made by the IFS cadres, not by the APFS, Arunachal Pradesh Forest Service.
Okay.
These are to be made by Bandardua is there, my lord, and Pasigat also, my lord, may take note, my lord, because with regards to this Pasigat also there was a matter, my lord, which this court has already decided, my. So, under this, my lord, even he is not eligible, my lord, to hold the post of the DFO Bandardua, but he has been allowed to hold that post because, my lord, there is a sometimes, my lord, the officers are not available, my lord, so that is done, my lord. Now, on this, my lord, if your lordship would, I've also given the judgment, my lord, WPC 331, my lord. Hano Moda, my lord, your lordship would see. Here also, if your lordship.
This is in case of Pasigat.
Yes, this is Pasigat. My lord has seen in the table, my lord. Pasigat also belongs to the IFS cadre, my lord. And if lordship may come to here, there are 5 and 6, my lord. Page 5, my lord. Para 5. Just what the contention of the petitioner was.
Yes. Yes.
Para 5. It is the contention of the petitioner that the respondent number 3, being an ACF, my lord will see, an officer in the entry grade, and that too on probation, is not eligible to hold the post of DFO, Pasigat Forest Division, as the post of DFO Pasigat Forest Division is to be manned by the cadre of ADCF senior grade. The respondent number 3 has been promoted to the post of ACF entry grade only on 25/3/2025 and is still on probation for 2 years. Therefore, he is not even a member of the regular service in the cadre of ACF. Even if his service is confirmed at ACF, the respondent number 3 cannot be allowed to be posted and hold the post of DFO as the same as to be mandatorily held by an officer in the cadre of ADCF senior grade. Therefore, the transfer of the petitioner who is entitled to hold the post of DFO Pasigat Forest Division by replacing him with respect number 3, who is an officer on probation and lower in the cadre, is not permissible under law as it violates the service conditions provided in the APFS rules 2019. 6, my lord. Aggrieved by the impugned transfer order dated 16/7/2025, the petitioner so and so. Basic contention, my lord, is seen paragraph 5, my lord. It's the same situation, my lord. And there also the petitioner was also not entitled, my lord, eligible, my lord. Now, if you also would come to page 17, my lord. And of course, lots have been discussed, my lord. That Hibutama and everything, my lord. And the division bench judgment where your lordship was there in Taban 26 months. In the present case, the petitioner has failed to show any adverse consequence on his service or career prospects or any prejudice, nor has any malafide or violation of any statutory rule has been alleged. Admittedly, he has been transferred after so and so completion 2 years as DFO as Itanagar as DFO to an equivalent post. Thus, this court finds no illegality or arbitrariness in the transfer order that so and so. 27, my lord. In view of the discussions made herein about those, court finds no ground to interfere with the transfer and posting order dated so and so, passed by the so and so, head of so and so, and so and so. Here also, my lord, this was dismissed, my lord, and then down below some observation was given, my lord. Because this post, my lord, even the petitioner is not eligible, my lord. This is, my lord, not a repetition, my lord. Seeking a writ of quo warranto, where my status is being challenged, my lord, where my eligibility to hold the post is being challenged. He has been transferred, my lord, in the headquarters, my lord, in his interest only, so that he can prepare his pension papers, everything, as per the transfer guidelines, my lord. And that post cannot be left vacant, my lord. So I have been, my lord, attached there, my lord. So what is wrong, my lord? Otherwise, also, he is not even eligible. I may also not be eligible, my lord. I am also not eligible, my lord. But these are arrangements, my lord, made, my lord. So the AP Forest Service rules, my lord, which has been relied upon, my lord, it has no application, my lord, for the post of the DFO Bandardwa. Because DFO Bandardwa is to be manned by an IFS cadre, my lord, not by the Forest Service, my lord. But these things have to be arranged, my lord, because of the, my lord, non-availability of the officers, my lord. There's nothing wrong, my lord, here. Here, my lord, that last portion, there's some direction was, however, considering that neither the petitioner nor respondent number 3 is entitled to claim the post of DFO Pasigat Forest Division, the respondent number authorities at liberty to pass appropriate order posting as a DCF IFS cadre officers DFO Forest Division. In the event of shortage of DCF IFS or an officer otherwise eligible to hold the post of DFO may be posted as deemed necessary by the competent authority. That direction was given. So here also, my lord, the petitioner who also has no right to hold that post, my lord, who has also been, my lord, given undue benefit, my lord, when he held the post of DFO Bandardwa. Now, when he has been transferred to the headquarters, my lord, in terms of the guidelines of the state, my policy, transfer policy, for his own benefit, my lord. And I am there just maybe as a temporary arrangement, my lord, or attached there. I'm only attached there, my lord. And the transfer order, your lordship has seen, it is not an interstate transfer, my lord. It is a transfer order of the so many officers, routine transfer, my lord. So there's nothing wrong, my lord. So that's why I'm, my lord, objecting to the interim prayer, my lord. It is his last 11 years, he says, my lord, let him go and rest, my lord, instead of being in the field work, my lord. Let him do his paperwork for pension, etc., my lord. Why he's so interested in the field work?
He will say, you wait for some more time. Okay. So I'll pass order day after tomorrow. Okay. List it again on orders for delivering of order. Hard Mr. R. Soikia, Learned Senior Counsel, assisted by IBAM, Learned Counsel for the petitioner. I've also heard Mr. Tapin, Learned Senior Government Advocate for the state respondent number
1
and 2. 1
1
and 2. Okay. And Mr. Okay.
I'm for 3.
for respondent number 3. Okay. Okay. List it again. On day after tomorrow would be 6. Okay. For
Till then, I may not be released, my lord, because they may,
That
my lord,
order
release.
may,
okay.
your lordship may
Then
pass, my lord. That is, that
then
amount
order,
of
then not day after tomorrow. I'll pass order.
Yes, my lord.
Okay.
Yeah.
I'll pass order. They are objecting stay. Okay.
All.
Item number 6.
Yes.
Wait, please, my lords.
Mm.
Well, the matter pertains to
This is
non-payment.
item?
I'm sorry.
5, no? Okay. Yes.
My lords. Wait, please, my lord.
Item 6.
Yes, my lord. The matter pertains to non-payment of contractual dues, my lords.
Okay.
The petitioner, my lords, was entrusted with construction of a godown, my lords, and Alo. He's completed the work. The project has been taken over, my lords. Only part payments have been made, and a sum to the tune of, my lords, 2 crore 56 odd lakh rupees is pending, my lords. We've submitted representations, my lords. They have not redressed our grievances, my lords. The amount is still pending. At this stage, my lords, I'm only praying for a notice.
Okay.
My lord, at this stage, notice may kindly be issued, my lord.
Okay. Hard, Mr.
B. Chaudhary, my lords.
Land counsel for the petitioner. Also hard, Mr.
BK Singh, my lord, for respondent number 1 to 5, my lord.
Okay. For respondent number 1 to 5. Throw VC, huh? Stop.
Notice upon, my lords, respondents number 6 and 7, my lords.
Okay. The case of the petitioner is that you have executed.
Executed, my lord. The project has also been taken over.
Where is the name of the project and all?
My lords, I'm sorry, my lord.
Where do we find the name of the project?
Yes, my lords may kindly have the contract, my lord, the agreement that was executed.
Page?
At page 30. Starts at page 30, my lords. 30 is a type copy. This is the agreement of 23/4/2018, my lord. The second paragraph, my lord, will see, whereas HPL is desirous of a construction of a 1670 106,670 metric ton capacity food grains godown, including infrastructure development.
Page 30.
30, yes, my lords. Is a type copy of the agreement, my lords.
Where is the name of the project? Executed the work for what?
My lords, the name of the petitioner, lordship will find that
name of the project.
Yes.
Which you have executed.
Yes, my lord. Second paragraph, my lords. Whereas HPL is desirous of construction of a 1670 metric ton
executed
capacity.
the work for construction of 1670 MT capacity food grains godown,
including infrastructural development.
including infrastructural development at Alo. Where is your work order?
Work order, my lord, there is an acceptance letter at page 27, my lord.
Pursuant to the acceptance letter dated
18/4/2018.
18/4/2018. Stop. Huh? Is submitted that out of what is the total amount?
Yes, my lords. That my lords will find for lordship's convenience, my lords.
Out of rupees
Yes, my lord.
5,63,200. 5 crore.
5 crore 63.
Yes. 29,413.
Yes.
He had been paid 3 crore 14 lakhs. However, the outstanding remaining amount of rupees 2 crore 56 lakhs 13,413 is yet to be paid.
Yes,
has not yet been paid despite of repeated request and reminder. So by this by filing this with petition, the petitioner is seeking direction to really direction to the respondent to release the outstanding contractual dues to the petitioner to the tune of rupees 2 crore 56 lakhs 13,413. Staff, para issue notice. Since Mr. Singh appears and have accepted notice on behalf of the respondent number
125, my lord.
125, no formal notice need be issued. Have you received the copies?
My lord, online I have received it. My lord, extra copies may kindly be served, my lord.
However, the counsel for the petitioner shall serve extra copies to Mr. Singh within 3 days from within a week from today. Staff, the petitioner shall take steps upon 6 and 7.
6 and 7.
6 and 7, madam.
6 and 7, by speed post as well as by usual process within a week from today. Staff, at least this matter after 4 weeks. Okay.
My lords, may I pray for a date, my lords? Possible.
4 weeks. Mr. Singh, is it okay?
After 4 weeks, my lord, today is 4, 1, 2, 3.
8th of June,
On
my lord.
1st of June, my lord.
As requested, list this matter on 8 June.
I'm deeply aware.
First of 8 June.
My lord, okay. my lord.
Okay.
I'm deeply aware.
Obliged,
Item
my
number
lord.
11.
May I please, Your Lordship?
Yes.
I'm for a petitioner, my lord.
You were to file additional affidavit.
No, my lord.
Or respondent, Mr. Soki, you are for.
Yes, I'm for the respondent number 429.
Who was to file affidavit, additional affidavit?
No, my lord, that part pleading is otherwise completed and then this
Today was fixed for hearing.
yes. On the last occasion, it was fixed for hearing, but due to paucity of time, it did not reach. So
For
today,
fixed for hearing.
Yes, Lordship.
Okay.
today is for hearing otherwise.
This is for hearing.
Yes,
My lord,
Lordship.
on the last occasion, my lord.
There was paucity of time.
Yes, my lord. On 33, my lord, this was listed for hearing and it was fixed on 28/4, my lord. But on 28/4, my lord, due to paucity of time, my lord, it did not reach. So this has been listed again, my lord.
It's for admission.
Your lordship.
It is already admitted, Lordship.
Orders.
Admitted, then it should have been listed in hearing, in the
30
hearing
March.
column then. By which order it was admitted?
On 30 March,
30
it was
March,
admitted.
33.
It's in the hearing column.
Today, my lord, is in the
admission,
my lord.
30 March.
My lord.
Yes, Lordship.
Where is 30 March order? No, there is no order. No any order. It was directed to be listed on 30th March for admission hearing.
Lordship,
After that, on 30, there was an order, man.
30, there was order. It's missing, it appears. Okay. You said that additional affidavit will not be filed. This order is not, where is 30 order? Where is that? It's not here. Okay. What is this then? Okay. Yeah, it's here. Hmm. Admitted, it should have been listed for hearing then.
It was listed on 28. man.
28 for hearing, and it was due to paucity of time,
Okay.
could not reach.
No, I have seen the order sheet and then it was not yet filed. And probably this is in that.
But subject to your
That
lordship's
no,
convenience.
here also same. Till that, no affidavit in opposition has been filed.
No, my lord, in the IA, my lord, I had filed the IA, my lord.
No, in the main petition also.
Yes, my lord. No, in
the
the
order
main
sheet,
pet- I had filed an IA, my lord, and your lordship had in fact passed the order, my lord, whereby that IA was to be treated as the
Part of
our, yes, my lord, our affidavit, my lord.
Hmm.
And in our IA also they filed a objection also.
Because,
Our IA, the IA on the part of the respondent 4 to 9, my lord.
because last order, the official office note generally we used to see, and then here I found that till that no affidavit is in opposition file. But that this
Your
need to be
lordship would
listed
see the order
for hearing, I think.
16/12/2025, my lord.
Mhm.
IA was to be treated as the
Yes,
counter affidavit, my lord.
yes, yes.
We have filed objection to that, Lordship.
Yes, ma'am.
Objection to the IA.
Yes.
IA, my lord. So
Okay,
that's why
so
my
that
lord,
will be
IA
treated,
was
then that is fine.
No.
It's fine only, but then this should have been, what is this matter, by the way, about?
My lord, here, otherwise the issue is very small, man.
Okay.
This, my lord, respondent 4 to 9, man.
Hmm.
They were given some work, man, for development of hydropower projects, man, in Italian, man, in Arunachal Pradesh, man.
Okay.
Now, since it's a hard terrain, man, the
Italian
officer-
Teju?
Yes, man.
Hmm.
Now, these persons, my lord, some employees, my lord, of the company, my lord, the PSU, who were transferred to Arunachal, man.
Hmm.
Considering the fact that this is a hard area, man,
Okay.
some incentives were given, man.
Hmm.
And then in that incentives, my lord, some officers were given some promotions also, man.
Hmm.
Those were some incentives, my lord. That was not as after the conducting a regular DPC, my lord, which is in fact postulated in the incentive program. My lord. Now that incentive, since some additional payments were made, my lord, there have been some audit issues, my lord, that was raised, my lord, by the ministry, my lord.
Hmm.
Now that's why, my lord, that the company, my lord, altered that incentive program. My lord.
In the meantime.
Yes, ma'am. After those objections were raised, ma'am.
Uh-huh.
Now, and accordingly, when those incentives, the earlier incentives were taken back, recalled back, my lord, the petitioner were put to the original, my lord, his cadre. Now, the case of the petitioner here is that he has got a promotion, my lord. It cannot be taken away. Like. Whereas our case is that
Right, already accrued to them.
yes, that is what the case of the petitioner is. Our case is that no, that was only an incentive, my lord.
Okay.
And in that incentive program also, my lord, circular also, there is a proper manner how it's to be done. Until and unless regular DPC is there, because there is a promotion policies also there of the company. Oh, the DPC has to be there, the performance appraisals has to be there, and if only the persons are eligible, because it is merit cum seniority, the promotions.
Okay.
That has to be considered. These people, these poor persons, my lord, who were here only as incentive that since you are working here, you take some incentive.
But earlier it was not named as incentive only.
No,
Yes,
it's
sir.
incentive only. It's in the circular itself, it says incentive.
Okay, not the promotion, but
Not
they
the
claims that they claims that it
It is, yes, now he's claiming that that right is accrued upon him as.
yes, that was a part that was a kind of promotion.
Yes, madam. That is the claim of the petitioner. And subsequently, madam, what has happened, madam?
So
Now this is the petitioner has been transferred, madam, out of
okay.
Arunachal also. It's been transferred to Bihar. And again after that, my lord, what the ministry has done, my lord, that project has been now handed over to the NHPC, my lord. In
The
fact,
project also is no longer.
no longer, my lord. We at least project will be there, but it will not be undertaken by the respondent. So basically, this entire petition itself, to my understanding, my lord, is in structure.
Okay. And
Because as long as he remained there, he enjoyed, my lord. But now once he has been transferred, and the company itself is winding up the operation from there, and it is being handed over.
otherwise, as long as they were there, incentive was paid. No.
Incentive was paid.
Okay, then what are you claiming now?
Lordship,
Just in short, but because today
that
honestly,
this company's action was arbitrary and illegal.
okay.
And the respondent, they have demoted me.
No, see, they said it's only incentive.
Yes, Lordship, but
It's a promotion, according to you.
yes. Let me give you, Lordship.
Take a little, I think, some time. So not today. There are other matters also, and I'm also not prepared today. I thought that this is additional affidavit is to be filed.
No, for hearing it was fixed for.
So this will be listed for hearing.
Yes,
We'll
Lordship.
fix the date, give her the date, fix for hearing, and we'll have hearing.
Yes, as per
Because
convenience.
already admitted.
Already.
Why
Yes,
should have been listed? Should have been listed in admission column. Should have been listed in hearing list only. Of course, date will be fixed.
No, otherwise, on the last date, it was listed for hearing only.
Is it?
But yes,
That's why it has come down again
That
I'm
we
not
don't
aware,
know.
ma'am.
We don't know.
I had no idea.
that
the
we have
time.
no idea.
So
But since in the hearing, my lord, it's in the last part, my lord, so we did not reach.
we'll fix the date for hearing. Okay. Miss Esmedi, land counsel for the petitioner, also had Mr. Soki.
And for respondent number 4 to 9.
Okay, land counsel.
Till then,
Hearing on behalf of the respondent number 4.
Humble-
Is for one.
my prayer, Lordship.
Sangeeta for 1 to 3. 1 or 2 only. Who is for 1 then?
Lordship, I humbly pray for continuation of the interim till then.
Okay. Mr. Parme, you are for? 3. And
Lordship, I'm appearing on behalf of DSGN.
okay. Then Katos first, huh? Miss, Miss, your good name? Lana Council appearing on behalf of Miss D, Mr. M. Katolana DSG. I. Sangeeta for 2. Okay. And Mr. Parme for 3. Mr. Parme for 3. And Mr. Soki for 4 to 9, huh? As agreed upon. When do you want, you said, by the Lana Council for the party list this matter?
Last week of May. May be on 26th of May, Lordship.
26 for hearing, huh? For hearing, clearly says, huh? Hearing.
26, my lord, is again Tuesday, then if there's
Tuesday again, of course,
DB
would
is
be a
there.
DB day.
will be there.
DB also, they are fixing any other date. It is coming on Monday also.
25th.
I don't know.
25th then, my lord. 25th, my lord.
Monday. Okay. Okay.
Next.
25th.
The interim order
25th
passed
May.
earlier. Shall
It's for
continue
hearing, Lord Chief.
till then. Okay.
Item number
Deeply
13
obliged,
and, 13 and 14.
Lordship, in item number 14, Standing Council FPSSB, he was supposed to take instruction from Pharmacy Council of India. And then item number 13, Lordship, in fact, this matter has become infructuous. Why? Because, Lordship, in this writ petition, in fact, we have challenged the advertisement, whereby in the previous writ petition, that we had a apprehension that post might have been carried forwarded to this advertisement, which is put to challenge in item number 13.
Put to challenge in item 14.
Yes.
In the 13.
13.
Has become infracture.
Since results are being declared now,
Okay.
it is presumed that the matter has become infructuous.
Okay.
So we can close item number 13.
Okay. Mr.
14 will remain, Lordship.
Okay, Mr. Genie, Land Council for a petitioner. Some states this writ petition has become infructuous, and accordingly, praise for closing the matter. Start
401.
This writ petition is dismissed on, they are closed on becoming infructuous. Okay.
And Lordship, in item
Disposed of. Okay. And in 14?
In 14, Lordship, I'm yet to receive my instruction. So I may be given 3 weeks time, Lordship.
Okay. 401. In 14, Mr. Tapin, Lanesh, government advocate submits that he is yet to receive instruction. Respondent number 3 has already filed.
Lordship, so far, affidavit is concerned that we have already filed. Some additional Lordship instruction.
Okay. By which order it was?
Last order, Lord.
Last order. Okay.
Let me see. 7-4, Lordship.
Okay. Receive an instruction in terms of the order dated 7/4/2026. And therefore, he prays for some more time. The prayer not being objected to by Mr. Genie, J. Genie, Land Council for the petitioner is allowed. Okay, list this matter.
Lordship, can we have a fixed date, Lordship? 27 of this month, Lordship.
Okay.
This holiday.
27 is on.
Holiday.
28.
Lordship, in next month, Lordship, 1st June or 2nd June.
Okay, as requested that this matter be listed on 1st June.
Second, sorry, 1st June.
1st June.
1st June.
Okay.
Lordship, that in fact, this is the second occasion that they are taking time to seek
Now,
instruction.
probably this time, because normally if it is an instruction, it is expected that you receive at least.
Actually, what happened here, Lordship, this is not exactly instruction from the department, Lordship.
Okay.
It's a dispute as to the Lordship, the equivalency of the degree. We have written to the Pharmacy Council of India, and we are still waiting for their reply.
Okay.
So our instruction is dependent on their reply.
Okay. In the meantime, that issue reminder also then.
No, that can be.
Okay. No, so that can be, because if the information is to come from outside, that probably will take time.
Lordship, in fact, even if that instruction they don't receive, Lordship, I have enough of materials to demonstrate.
Okay, then let us see on the next date. Next date, if the instruction doesn't come, let us try. Okay.
Item number 17 and 18.
Thank you.
May I, my lord?
Yes.
My lordship, we need some more time to file affidavit. We haven't received a paragraph reply yet.
Okay, this Public Service Commission.
No, Your Lordship.
The respondent is whose?
For 2 and 3 Public Service Commission.
Okay.
And
The IA is for what?
I is for the stay of the further process of the adjournment.
Okay. So instruction with regards to what?
paragraph reply.
Reply. So it's IA
No.
in the main.
Main case.
Okay.
Your Lordship, as regards to the reply to be filed by the state, it has been more than 3 times that they are taking time. So
Oh.
my prayer is that they may be directed to file reply without fail by the next day. And this is your the case.
The occasion. You ensure that next time you file prior to the next date.
Even on 13 to 2026, Your Lordship, they were directed to file within 10 days, but which also they failed to comply. So this time they may be directed to file without fail, Your Lordship. That is.
Okay. Ms. Wang, Lanet Government Advocate for the state respondent number
5, 6, and 8.
1 also?
Yes, Your Lordship. 1, 5, 6, and 8.
1, 5, 6, and 8. Some is said she yet to receive instruction.
Paragraph reply.
Okay, yet to receive the paragraph reply, due to which she could not file affidavit in opposition. Therefore, pray for some more time. Okay. Mr. Tara, are you also filing affidavit?
I have already filed.
Oh, already filed. And what about you, Ms. Anju?
We have already filed.
Already filed?
Yes.
It's also, okay. Then, who is for?
Sajeta also, they have filed. Sajeta.
Okay.
Only PW, respondent number
The
5, 6, and 8.
Ms. Anju, Standing Counsel for the Arunachal Pradesh Public Service Commission. Respondent number 2 and 3.
Lordship.
And Lising, you are for? Okay. Tara is for
7.
7. Who is for 4, 5? Sorry. 4 for social justice.
Sajeta.
That is.
Okay, he is not there.
No.
He has filed. Oh, he has also filed.
Sajeta has filed, but the.
Okay.
But the 5 has not filed.
5 has not yet filed.
5, 6, and 8.
Okay, 6 and 8. Who is for PWD?
I am there, my lordship.
Okay,
5,
okay,
6,
sorry.
and 8.
6 and 8, okay. 7 is RWD. Okay, Mr. Tarak, huh?
Yes.
For respondent number 7 only.
7.
Okay. And leasing permit for 9 are also present, huh? Miss Wangmo, a counsel appearing on behalf of respondent Messrs. So and so, huh? Shall ensure filing the affidavit by the next date. Okay. Then Mr. Taja, K. Taja, Lana counsel for the petitioner. Before this, ensuring Wangmo, huh? Some is that it has been all other respondent has filed except the state respondent. All have filed, huh? And they except the state respondent, huh? Therefore, the state may be directed to may be given a last chance to file affidavit. Stop. In view of the above, Ms. Wangmo now shall ensure filing affidavit in opposition by the next date. Stop. Next date of the case is fixed.
Maybe 18 May.
18 May is 18 May.
Monday.
Why 18 May? She's seeking some time.
Because you see, the case is a very urgent nature.
What is the urgency about this?
It's regarding the recruitment of the APPSC in respect of the PWD person with backward benchmark disability. And
Advertisement issued.
yes. And
What happened? Interview conducted?
interview conducted. Now, but the result of one department is pending, and the persons, they are yet to be appointed. So if they are appointed,
Okay, it is pending only because of this writ petition.
yes, yes.
There is a stay.
No
No.
stay.
No stay.
No.
Now it appears that this is also, there is some urgency.
Otherwise, other all departments which are already declared.
Okay.
The only civil is yet to file, yet to declare the result. for
Okay.
Civil, junior engineers, civil, your lordship.
Okay. Then if that also is declared, then in that
Results already declared,
no, the civil.
civil.
Ah,
For mains, already results declared. Now interview is going on, your lordship.
okay.
So there's an urgency in this matter because they have
Then
put
in
to
that
challenge.
case, you have to file.
Yes, your lordship. They
Okay.
have put to challenge uneven distribution of
You see into it.
reservation,
You see into it also. So when do we fix then? In that case. 25th. Okay. But before the next day, she should ensure filing, huh? The affidavit before the next date, huh? The next date, which is fixed on 25th May. Okay.
Obliged.
Item number 19.
Yes.
Hello, sir. This morning I have filed affidavit of reply. Respond number 6, 2, 3, 7 and 8, 11, 15 and 17. And respondent number 12, 13, 14 not yet filed in opposition.
Not yet file affidavit.
Yes, sir.
Okay. So have you received the copy?
Yes, my lordship, we have.
Jitar, have you also received the copy?
Yes, I have filed my.
Okay. Have you received no affidavit in reply in or to the affidavit filed by whom?
2, 3, 7, 8, 6, 11, 15 and 17.
Okay, so I could not follow because it was not in a serial. Okay, Mr.
B. Sibo on behalf
Sibo, Land Council.
On behalf of Tai Siba.
Appearing on behalf of Mr. Tai Siba, Land Council for the petitioner, submit that he has filed affidavit in reply to the affidavit filed by the respondent number 2, 3, 6, 7, 8, 11, 15, and 17. However, he submits that the respondent number 12, 13, and 14 are yet to file their affidavit in opposition. Staff, huh? Mr. Tar, have you filed? Okay, and one for the government.
We have filed, my lordship, but we need some 2 more copies for land department. Earlier there was
Land department is 12, 13, 14.
no, 4 and 5.
Oh, 4 and 5.
And
Oh,
not-
4 and 5 also not yet filed.
Yes, Lord.
Because there was standing council. Now we.
Okay, stop. Ms. Wang will submit that. Although she has filed affidavit in opposition on behalf of respondent number
6, 15 and 17.
6, 15, and 17. However, due to lack of copy, she could not file affidavit. She could not. Have you obtained instruction? Not yet.
They have not.
Okay, she could not obtain instruction in respect of the respondent number 4 and 5. Stop. Mr. Sibo, Land Council for appearing on behalf of the petitioner shall furnish 2 extra copy. 2 or 1?
2, my lordship.
2 copies. Extra 2 copies of the petition to the Land Council within 2 days.
Yes, Lordship.
From today, stop, huh? In view of the above, let this matter be listed after 3 weeks.
Yes, Lordship.
Okay, so in the meantime, you file a, obtain instruction and file affidavit on behalf of the rest of the respondent. Okay.
Fabulous.
Item number 25.
Okay. Here, Mr. Rama prayed this morning. Okay. Right. Mr. Rama, land counsel for the respondent. Submits, prays for some more time to file affidavit. Prayer aloud. List this matter after 3 weeks. Where is this item 25? Just once.
Yep. By mistake,
Hmm?
by mistake, he gave to the place. He's bringing.
Okay.
Shall I call item 26?
Item next.
Okay. Item number 26.
May I please, Madam?
Yes, sir.
Madam, today I have filed Wakalat Nama for respondent number 2 and 3. So in case of respondent number 2, Manesh Gupta, he is chief secretary. Respondent number 1. His name is, as per name, he is chief secretary of the government of Arunachal Pradesh, but the secretary to the government of, even in the para, it should be secretary RWD. So his name may be extra, he is nothing to do with this case.
It is just a typographical mistake. He's Manish Gupta. He's the head of the department, RWD department. So it's very pertinent that it comes to his knowledge about this matter. So it's just a typographical mistake. We can correct it.
Respondent number?
1.
1. Okay. Miss
J. Das.
Land counsel for
Secretary RWD is the head of the
petitioner.
department, not the chief secretary.
It's just a typographical mistake.
Sami said there has been some typographical mistake with regards to the respondent number 1, and therefore pray for allowing her to amend the said mistake by filing amended. You have to file amended course title in that case by filing amended course title, for which she prays for how many days?
How many?
1 day will 1 week will
One
be
week,
enough.
one
Okay.
week, one.
1 week.
In that case, respondent number 2 will also
The
have
prayer
to
is
be.
allowed. Respondent number 2 is?
2 is chief engineer. Actually, this project falls under PMGYs.
And that also you have to correct.
Okay. Okay.
Okay, then typographical mistake with regards to the respondent number 1 and 2 in the course title, huh? Therefore, she prays for allowance. Same, huh? Okay, the prayer is allowed. 1 week time, huh? Prayer is allowed, huh? Then you represent respondent number 1, 2, and?
No, 2 and 3. Now it will be 3. 3 is the main only person.
Okay, so not yet file any affidavit.
Today we are appearing only, first time.
Okay,
For the first
Mr. G. Tarak, Land Council would appear on behalf of the respondent number 3.
Yes.
So 1 and 2, when you make correction,
then
then they'll appear.
Okay. But Your Honor, on the last occasion, we were directed to serve notice through Dusty. We have served.
But then the name itself is
Yes,
not
yes,
correct.
yes, okay.
Now they'll say,
Okay.
this one is not me.
Yes.
Okay. And prays for some time to file affidavit in opposition. You want to file affidavit in opposition?
Yes.
Okay, the prayer is allowed. Okay. Age prayer for comma. List this matter after 3 weeks.
3 weeks, okay.
Okay.
Published.
25, no? Okay, just a minute, huh? Then Mr. Ramaha would appear on behalf of the respondent and press for some time to file affidavit in opposition. Affidavit and necessary affidavit. Just a minute. But he is for respondent. And prays for some time to go through the matter. Prayer allowed. List this matter after 3 weeks. Okay.
Item number 27.
Yes.
Lordship, we need some more time to file our affidavit, Lordship.
You are for respondent.
Yes, Lordship.
Who is for a
Respondent-
petitioner?
Petitioner.
Okay. You are for the DSGI.
Yes, Lordship.
And you?
I'm appearing for respondent number 678.
You are also filing?
Yes, I have filed.
Okay. Both the Miss appearing on behalf of Mr. M. Katolane DSGI and Miss Basar Lana Council appearing on behalf of the state respondent. DSGI, how many?
For respondent 1 to 5, Lordship.
1 to 5 and Miss Basar for state respondent number
6 to 8.
6 to 8. Praise for and are granted 3 weeks time to file affidavit in opposition. Okay. List this matter after 3 weeks. Okay.
Item number 32.
Yes.
I'm for respondent number 1, Your Lordship. I need some more time, Your Lordship, to file the reply, Your Lordship, to counter affidavit, Your Lordship.
You are for the petitioner?
No, respondent number 1, Your Lordship.
Okay,
Lordship,
then.
the counsel for the petitioner has expired, Your Lordship. Counsel for the petitioner has expired, Your Lordship. On our last occasion, Your Lordship, it was informed to this honorable court, Your Lordship.
Who is the counsel for the petitioner?
I Ahmed, Your Lordship.
I Ahmed. Fine, no more.
Yes, sir.
Ready?
It's on order dated, Your Lordship, 11 March 2026, Your Lordship. On the order dated 11 March, Your Lordship, in that order, Your Lordship, the registry, it was written that the registry shall issue notice to the petitioner by speed post informing about the pendency of this case and for making alternative arrangement.
Counter affidavit. 11 March. Who is the other advocate? Okay, only one advocate appear on behalf of the petitioner. He is no more. Okay. But none appears for the petitioner on call. It appears that the office, the registry has issued notice to the petitioner on 27/3/2026. Informing regarding the passing away of the counsel for the petitioner. However, no one appears on behalf of the petitioner. The registry shall issue a reminder to the petitioner, issue a reminder to the petitioner by speed post, informing about the demise of the counsel for the petitioner and for making an alternative arrangement to represent his case. Staff fair. Mr.
T Norbu, Your Honor.
For respondent number
1.
1 and above for Chibo for
Respondent number 2.
2 are also
On
present.
behalf of T. Tapak, standing
Appearing
counsel
on
of,
behalf of Mr. T. Tapak,
standing counsel of IS.
standing counsel of IOC. Also submit, also pray for some more time to file affidavit in opposition. Okay. In view of the above, let this matter be listed after 3 weeks. Okay.
Yes.
Item number 33.
Yeah, Your Lordship.
Yes.
Service of respondent number 2 is still awaited, Your Lordship.
Miss
I'm sorry.
and counsel for the petitioner is present. The office note dated 2/5/2026 reflect that the service of notice upon the respondent number 2 is still awaited. In view of the above, let this matter be listed after 2 weeks.
2 weeks. Obliged.
Item number 34.
Your Lordship, we have taken the steps by issuing a notice, but we haven't received any response till yet.
You are for?
For the sole respondent.
Sole respondent.
For the petitioner.
Is there then?
My Lord, we have filed a wakalat number today. We are seeking some time.
Miss?
Biri Esther.
B?
Biri Esther.
Biri Esther, Lana counsel for the petitioner. Okay. Mr.
G. Talo.
G.
Talo.
Sorry. Talo. Lana counsel would appear on behalf of the sole respondent and prays for some time to file affidavit in opposition. Okay. You want to file affidavit?
Oh, yeah, we
Will
would like to
receive the
file a
copy?
reply. We have filed a reply.
Okay. The prayer is allowed. List this matter after 3 weeks. Okay.
Much obliged. Your Honor.
Item number 35.
My Lordship.
Yeah.
My Lordship, we need some more time to file an affidavit.
Okay. Ms. Wang, Land Council, Land Government Advocate for all the respondents.
No, my Lordship, 1 and 3.
Respondent number, state respondent number 1 and 3. Prays for further, how much time?
2 weeks more.
Further 2 weeks time to file affidavit in opposition. And how many respondents are there? Other respondents are also there.
2 is there.
2 more.
1 more is there. Respondent number 2.
Respondent. You are for 1 and
3.
3. Okay, 1 and 3, huh? Then district president BJP Anjo.
Your Lordship,
To which Mr.
Mr. K time.
K.
K time.
Lana Council for the petitioner has no objection. Prayer allowed. Have you taken steps upon the respondent number 2 also?
Yes, Your Honor, but the service is still awaited. So, Your Honor, the dusting will be
Okay.
allowed, Your Honor.
Okay, then Mr. K. Time.
K time.
Lana Council for the petitioner. Okay. Now, in view of the office note dated 2/5/2026, Mr. K. Time, Lana Council for the petitioner prays for allowing him to take first steps upon the respondent number 2 by way of dusty service. The prayer is allowed. Staff. Dusty upon the respondent number 2 be taken within 2 weeks from today and file affidavit to that effect. Okay, so list this matter after 3 weeks. Okay.
Item number 39 to 41.
30.
9 to 41.
There is supplementary.
Yes, Lordship.
This was not notified. Yes.
Your Lordship, I'm for the respondent. In item number 39, I'm for the respondent number 11 to 20.
11
to 20.
Okay.
In item number 40, 10 to 15.
Okay.
And item number 41, 4 to 8.
Okay.
Your Lordship, in item number 41, the service upon respondents was completed.
You are for?
I'm for the respondent.
Respondent only?
Yes. Only in the item number 40, the service was completed. And in item number 39 and 40, there were certain respondents, their service was yet to complete. So,
okay, just a minute. Huh? Okay, this is fixed method, that's why.
This is fixed method.
Not appears on behalf of the petitioner. However, Mr. Jambe Siri. No, Miss Sangeeta for? In all the case, like a government advocate appear on behalf of the respondent number 1, 2, and 3 in all the writ petition. And Mr. Jambe Siri for respondent number 1 to 20.
11 to 20.
In
11
11 to 20 in item 39, comma and semicolon. 10 to 15 in item 40. 40 means WPC 337 2025. And for respondent number 48 in item 41, WPC number 338. You are also seeking time?
Your Lordship, affidavit just yet to file. You will file for 2
Okay.
weeks.
Both the counsel appearing on behalf of the respondents sought for some, how much time? 3 week time? Oh, you have already filed? Okay. And then prays for some more time to file affidavit in opposition. The prayer is allowed. List this matter after 3 weeks.
3 weeks.
Okay. Is there any stay here? No.
Yes, no.
Okay.
Just
Matter is over. Matter is
So,